Everyone. Bridgewater Township Zoning Board of Adjustment, regular meeting, Tuesday, November 25th, 2025. The time is 7:06. Adequate notice of this meeting was provided in accordance with the Open Public Meetings Act, NJSA 10:4-6, specifically on January 15th, 2025. Proper notice was sent to the Courier News, Star Ledger, and filed with the clerk of the Township of Bridgewater and posted on the Municipal Bulletin Board. Please be aware of the Zoning Board of Adjustment policy for public hearings. No new applications will be heard after 9:30 p.m., and no new testimony will be taken after 10 p.m. If you're able, please rise for the salute to the flag.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right. Good evening, Nancy. If we could have a roll call, please.
Chairman Foose.
Here.
Mr. Wadley.
Here.
Mrs. Amin.
Yeah.
Mr. Sweeney. Here. Mr. Fresco.
Here.
Mr. Bongiorno.
Here.
Mr. Gajewski.
Here.
Mr. Seacat will be absent for the record. Mr. Kulak.
Here.
Mr. Vesio.
Here.
Mr. Gabbett.
Here.
Mr. Aller, board
Here.
attorney. Mr. Burr, board engineer.
Here.
Sarman, board planner.
Here.
You have a quorum, you can proceed.
All right. Thank you very much. This time, I'd like to open up the meeting to members of the public that would like to speak on any land use issue which is not on our agenda this evening. You can come forward. Seeing none, I'm going to close that portion. We have no minutes for approval tonight. We have two resolutions. First up, we have 14 Gateshead Drive. Looking for changes, comments?
You're good.
All right. Motion, please.
I move.
All right, Mr. Wiley, second? Second, Mrs. Amin. Thank you.
Mr. Foose.
Yes.
Mr. Wadley.
Yes.
Mrs. Amin.
Yes.
Mr. Fresco.
Yes.
Mr. Bongiorno.
Yes.
Mr. Gajewski.
Yes.
And Mr. Kulak.
Yes.
All right. Second, we have 797 Country Club Road. We had changes today from Board Attorney Aller that were emailed to everyone. Looking for further changes or comments?
I move with his changes.
Yep, and there are a couple of others, just a couple of buzz and that we're missing that I'll put in, but nothing that changes the
Okay.
substance.
Do I have a second, please? Mrs. Amin? All right. Thank you.
Sorry, who made the motion?
Jim?
Mr. Foose?
Yes.
Chairman Foose, sorry. Mr. Wadley?
Yes.
Mrs. Amin?
Yes.
Mr. Fresco?
Yes.
Mr. Bongiorno?
Yes.
Mr. Seacat is absent. Sorry, I'm moving on. Mr. Kulak
Yes.
and Mr. Vesio. Voting for.
I'll abstain from voting on this one because I was not present at this meeting.
I was going to say that's too many at that point.
Well, Mr. Gajewski voted no.
Well, that's okay.
I didn't vote.
Just the yes votes who vote on this.
All right. So we're good?
Yes.
All right. Thank you. All right. Our application this evening is 821 and JCC, Somerset, Hunter, and Warren. Mr. Cohen and Mr. Coakley, good evening, gentlemen.
Chairman and the board, Kevin Coakley, Connell Foley, on behalf of 821 Bridgewater. And with me is Howard Cohen on behalf of the Jewish Community Center of Somerset, Hunter.
Mr. Coakley, with your permission, at the prior hearing, a neighbor inquired about access to the emergency access in the event their property was flooded or otherwise impaired. We have consulted with our engineers, we've consulted with 821 Bridgewater, and we consent to the neighbor access onto the emergency access in the event of an emergency, so long as the design of the emergency access as identified in the exhibit and evidence is not changed, so that the point of access onto the JCC property would be as shown on the emergency access exhibit. Thank you.
Thank you, Mr. Cohen.
In that regard, 821 as well would work with the homeowners to the south of the project to provide them emergency access along the existing proposed emergency access way. And presumably, if this were approved, it would occur at the site plan stage, the details of that. So this evening, I have two witnesses to be called essentially for cleanup purposes for different reasons. So it'll be Mr. Keller, the traffic expert who's testified previously, and Mr. Steck, the planner, who's also testified previously. So I'll be calling them for rather limited purposes. The other point I'd like to raise to the board is, how many members are present who can or are eligible to vote this evening? I know some are not. I don't know what the numbers.
We have signed affidavits, so we have 7, right?
Correct.
Okay. All right. Thank you. All right. So with that, unless you have some questions, I'd like to call Mr. Keller.
Sure, that's great.
Eric, would you raise your right hand, please? Solemnly swear that the testimony you give to this board will be the truth, the whole truth, and nothing but the truth?
I do.
And for the record, your full name, please?
Eric L. Keller, K-E-L-L-E-R.
Keller, you've testified previously on this application before this board?
I have.
All right, and in your November 12, 2024 testimony, you stated that the proposed project would generate a nominal amount of additional traffic beyond what is currently generated by the farm stand.
That is correct. That was in our report dated January 29th, 2024, revised October 9th of 2024 in what I believe is Table 2.
All right, and you testified at that time that the proposed traffic will not materially impact the safety of the intersection.
That's correct. The proposed roadway intersection with Route 202, 206 would operate at an acceptable level of service.
All right, and you did a site distance study?
We did. We worked with Mr. Michello's office. They prepared the drawing, and based upon our analysis of the roadway operating conditions, and there is in excess of 600 feet of sight distance in either direction from the driveway, looking both to the north and to the south.
And at the time you testified in 2024, Sergeant Hennessy had not submitted any report as of that date?
I don't recall. There might have been a report, but there was nothing of substance to my knowledge in the, I think there have been 2 reports from the sergeant.
First one, he said he had no comments to the application.
Right.
And during the course of these proceedings, you did an OPRA, that's an Open Public Records Act request for traffic accidents between West Foothill Road and extending southerly across the site frontage to Talamini Road. Is that accurate?
That is correct. We submitted it, the OPRA request. It was received by the Township Police Department on September 9th, 2024, and it was seeking accident reports from January 1 of 2020 to 9/9/24 from West Foothill Road through the existing farm stand driveway, which is south of the proposed road intersection and also the vet hospital driveway.
And in 2024, when you testified, did you disclose in your testimony what the extent of the OPRA was? In other words, did you describe what you had OPRA'd?
That is correct. It was contained in that same traffic report I referenced previously. On page 8 of that report, we summarized it, and it had returned 2 accident reports, both of which were at the vet hospital driveway, and based upon reviewing the statements within each of the reports, those accidents were caused by driver distraction or inattention and not due to operating conditions or roadway conditions in that vicinity.
Did you, when you previously testified, and now, do you consider the scope of your Oprah request to be appropriate?
Yes, they do.
And after you testified, Sergeant Hennessy of the Bridgewater Police Department filed another report on February 18th, 2025. Is that true?
Yes, correct.
And you referenced that there were the number of accidents in your prior testimony that you got as a result of your Oprah.
Right, there were two.
Okay. And did Sergeant Hennessy submit an Oprah request?
I don't think he has to submit an Oprah request to his own department. He was able to collect the accident reports from the police department records as part of his undertaking.
Okay. Did his list of accidents coincide with your list of accidents?
Well, his report indicated there were 23 accidents. However, he covered a much greater length of roadway than we did. We were focused on where we were proposing access. The additional crash records that were reported by the sergeant, where is it? They encompass an approximately 1.4 mile segment from Allen Road to the south to Heather Hill Way, plus there was one crash that was in that data set that was at Corporate Drive, which was another 0.8 of a mile to the north. So it was 23 accidents over a 5-year period in essentially a, call it a 1.5 mile segment of roadway, of a state highway. So there were many more, but it was because it was a greater distance. I don't think it, in my opinion, my professional opinion, it doesn't change our findings. You know, these accidents occurred at other locations and are not indicative of where we are looking to create a new driveway access.
I have a question. Did your Oprah request and response include accidents on Talamini and any of the roads, like Foothill
We included West Foothill,
and Talamini?
We did not include Talamini because it's a signalized intersection and it's at a greater distance from the site than we thought was appropriate for this proposed access. So no, we didn't include Talamini.
I have a question for you. See, depending upon how much traffic is coming out of that housing complex, if they are driving on 202, 206, 4 miles down, 10 miles down, if that increases the accident rate, how do you look at it? I mean, it's not within 2 miles or 5 miles. I mean,
Well, the amount of traffic generated by this site in comparison to the amount of traffic already on 202, 206 would not materially affect the accident rate because it's such a small percentage of the overall traffic. Traffic volumes by themselves do not relate to the rate of accidents. Accidents are usually based upon vehicle miles traveled. It's both vehicles and miles. This project generates such little traffic compared to what's already there, it does not make a material difference.
Were any of those accidents with injury?
The two that came out of my Oprah request, no, it was property damage, vehicle damage, but no injuries.
I have a question. How would you feel about a condition for no left turns coming out of the development?
Given the amount of sight distance there, I don't think it's appropriate.
You don't-
Would also
Wait, I'm sorry, you don't think, you
make,
think you should be able to make a left turn?
absolutely.
So you would be opposed to that condition?
I would.
Thank you.
Just a quick question about what you just stated, that traffic volume has no impact on accidents, is that what you said?
I didn't say it had no impact.
What did you say?
That in this case, this project, the traffic from this project would not have any material impact upon the types and number of accidents that would occur within this corridor.
I heard that, but I thought you made also a statement that was more general about traffic volume not impacting an accident rate. So if I misheard you, or you just threw that in as a filler, your point is better stated as the, let me see if I can reconstruct it for you. The amount of traffic that you anticipate being generated by the site would be incidental in the sense that it wouldn't cause any additional traffic accident, in your opinion.
Correct. And
Fair to
also
say?
the fact that traffic volumes by themselves,
That's what we're getting at.
right, traffic volumes by themselves do not create accidents. It's the levels of service that are provided, the roadway conditions. It's not whether I have 100 vehicles or 200 vehicles. Because I go from 100 vehicles on a roadway to 200 vehicles, doesn't mean I'm going to have twice the accidents.
There's not
Not
a
a
one-to-one
proportion,
correlation
it's
is
not
what
a
you're saying.
linear-
But we all live in this area, and we just drove here through tremendous volumes of traffic, some of which are affected by the holiday. You can't tell me that the volume of traffic does not have an impact on accidents. It doesn't compute for me. I appreciate your opinion, I'm just stating mine.
Understood?
On that point, though, you said, so you're kind of looking at sort of just the plus few cars, but you're adding an intersection here. So how does adding an intersection to a road like 202 impact roadway safety?
That's why we look at sight distance, we look at visibility, the operations, and the level of service. Those are the factors when you design a new intersection that you can't design for driver behavior in any road. You can't design for driver behavior fully. I mean, you design roadways so that they have the appropriate geometry, vertical geometry, sight distance. But as I said, the two accidents that occurred at the vet hospital were caused because the driver was not paying attention.
How do you know that?
Huh?
How do you know that?
It was stated in the accident reports as to why that occurred.
Who stated it?
That was written by the police officer. He wrote, your police officers do a great job of actually putting usable information into their accident reports. I don't have it with me. I don't remember the specifics, but it was clear, whatever it was that the driver was not paying attention. They were distracted by something, and they had an accident.
So the police gave you the police reports from the Oprah request? Because I have the Oprah request here. It doesn't say that they supplied you.
No, I have a whole stack of
Well, listen,
actual accident reports.
Mr. Keller, I'm glad we finally agree on something. Our police department is tremendous, and my hat's off to them. So, all right, good, thank you.
Chairman Foose, just so you know,
Yep.
the report that the Lieutenant Hennessy had submitted, that included the actual Oprahs as support to the map that showed where all the accidents were located.
Okay.
And I just want to clarify, because I don't believe that that's an accurate statement, that the driver was distracted, actually. In one of the cases, the driver was distracted, and that was noted in the accident report. But if we're looking at the same one, which is number 17, which was the other one, it actually noted that the driver had someone pull out in front of them, and their view was obstructed, and that's why there was a collision.
Well, I'm a customer of that vet, and yes, that happens there.
So I just want to make sure that, yes, in one case, it was noted there was a distraction. In the other case, there was nothing. It says failed to yield to oncoming traffic, which is not a distraction, but rather
Right.
and a driver error.
Mr. Keller, how did you pick in the Oprah January 1st, 2020 during COVID? You know, I hear your testimony about the number of cars is not correlated to the accident numbers, but you have to be curious that maybe in 2019, maybe in 2018, there were more accidents. I know there were substantially less cars, and I can testify that my car was out on the road for a substantial time during COVID, and thus, you know, people not reporting to work and remote working, the traffic has decreased. I am curious, but do you have an opinion on that?
Generally, we collect data for 5 years.
Gotcha. So you did it
And
for
it's
here.
always, I mean, they were very strange times, you know, but I felt that that was representative. And considering we got 2 hits, that they gave me 2 accident reports. That was it.
You don't have
They
any
were-
data for 2019 or
I
2018?
did not ask for 2019 or 2018.
So it's a bit arbitrary in the selection of 2020 to 2024?
No, I don't think it's.
You just testified that you typically pull 5 years.
I did. I pulled 5 years, 2020 through September of 2024,
5 years. It's less than 5 years.
by 3 months.
But don't testify that it's 5 years when it's only less than that.
It's 5 years and 8 months and 9 days.
Okay, so you don't have any 2019 data before
I
COVID?
do not.
So in your professional opinion, when was the official dates of COVID, when traffic was impacted?
About the middle, it was like March 17th, March 20th, something like that. So we got 2.5 months of 20.
And following COVID, have you, in your professional opinion, noted a decrease in traffic due to remote working?
Sure, there's been a continued reduction in traffic volumes since COVID ended. I mean, as a pandemic.
So you selected a time that not only has COVID in it, but has decreased traffic quantities due to COVID-related office remote working.
And traffic volumes are still decreased than they were.
All right, just wanted to get it on the record. Thank you, sir.
I have another question. Time of day, the majority of the accidents is after 5 o'clock?
I don't recall, sir. I didn't bring,
I have information that gives me times, and it looks like the majority of
Gotta be
the
careful with
accidents
this.
are after 5 o'clock.
So he's putting things on the record.
Would you object to no left turn after 5 o'clock?
yes.
Okay.
It's an enforcement issue for your police department. There is no engineering reason that they can't make a left turn out of that driveway. They make a left turn out of the vet hospital, Chairman Foose has probably made that 100 times.
No, I go right on Foothill. But since you brought it up, I did go to the site today, and I did try and make a left at Allstead Farms. Did any part of your traffic report, there's a functioning farm stand there? I mean, it was busy today. I went at 1 o'clock today. I mean, theoretically, could there be less traffic from this residential component than currently exists at Allstead? Yeah.
Yeah, at busy times, around the holidays, I mean, Allstead Farms is well known. People like to go there.
Has anybody recorded this information? You know, I don't even know if this is an approved use, because we're in an R40 zone and there's a farm stand there, but that withstanding, I mean, could there be less site trips?
It's possible. I mean, in our report that we submitted last year, we used DOT data. We did not do a traffic count of the farm stand. I don't even know if it was open at the time we did the traffic count. We counted at Foothill Road and we counted at Halloween. We did a comparison based upon the trip generation that the DOT publishes. We used DOT rates, which are also much higher than, we're now up to the 12th edition of the trip generation. It's gone down again. There is less peak hour traffic because of remote work, because people are working different hours. So but we use the numbers that we would use when we go to the state for access permit. And, you know, the proposed development will generate nominal amounts of traffic.
How much is nominal?
Based upon, we had this debate last time, I'm not going to, I don't want to debate it again.
I'm tired too.
I'm going to use market rate, non-age restricted townhome.
It's not my question, it's Mr.
I know.
Bongiorno's, yeah.
I'm not looking at you directly, Mr. Foos, Chairman Foos, I'm sorry. Just in general. So the DOT trip generation says there's 37 AM peak hour trips for 64 units and 44 PM peak hour trips for those same units. So it's less than 1 a minute. And that's in 2 directions, both entering and exiting. Obviously, in the morning, more people are going out, and at night, more people are coming in. So that to me is nominal. It's nominal to the DOT. Anything less than 100 peak hour trips, they consider that as no significant amount of traffic. You're welcome.
Mr. Keller, when you testified about a year ago, you assumed there would be 60 units on this project, is that
Correct.
correct? And now the
I
application...
didn't assume it's what was on the
It was what, yes. You based your testimony on 60
Correct.
units. And if I told you now that there was going to be 64 units with 13 one-bedroom affordable units, would that change your prior opinion about the traffic impacts of the project?
No. And actually, the numbers that I just quoted to the board were for 64 units. If we did it for 60 units, there'd be 2 less in the morning peak hour and 3 less in the PM peak hour. So it is a negligible change.
And when you previously gave a report, did you say something, and I'm paraphrasing it, that the proposed project would generate a nominal amount of additional traffic beyond that which is currently generated by the farm stand?
Correct, correct. They said table 2 in our traffic report from last year showed that there were, if I compare the current plan, 64 units to the farm stand, there would be an additional 17 AM peak hour trips and an additional 6 PM peak hour trips. Again, this is based upon data published by DOT.
Okay, I don't have any further questions for the witness.
Board questions, Mr. Keller.
I have a question.
Please.
So, Mr. Keller, for me, I think your data is great. I like the data, about the volume. But, what the data can't convince me of is safety. There's a lot of intersections where I sometimes pull in and I see somebody here and I see somebody here and I see a guy coming up behind me and then another person is coming out here. So tell us where in the data it says that this is safe, regardless of volume. Is it safe? Can a 60, geez, I'm getting up there myself. Maybe I should go higher.
I'm already there.
Yeah, maybe I should go higher. Maybe go.
You look like a child.
Yeah, thank you. Maybe a 78-year-old person is going to be able to process the vet, Foothill, West Foothill. Are they really going to be able to process that safely, regardless of volume, just safety?
So volume is not, as I said, volume is not necessarily a function or a causal factor of safety. Well, we looked at sight distance. There is more than enough sight distance to see approaching vehicles along 202, 206. We made the decision, the farm stand driveway, this came up in Mr. Michello's testimony at the last meeting, about the farm stand, which is not aligned with the vet hospital. We made the decision in looking at the plan that it is better for these 2 low-volume uses to be aligned. There are design standards about separation between driveways. the proposed driveway and Foothill Road are separated by a sufficient amount of distance that if somebody is making a left out of Foothill Road, and somebody makes a left out of our site driveway, there is plenty of distance that they can see each other and process that. West Foothill Road is about 400 feet away. So that, in my opinion, does not even factor into the equation of how this proposed driveway will operate. Their part, they would be part of the through traffic on 202, 206 at the point they get there. The other thing that we chose to do, because the vet hospital already has a left turn lane into that hospital, into their driveway, is that we would, as part of our DOT access permit, would create a left turn lane opposite that, so that the left turning traffic into this site is not placed within the through lane, the through traffic of Route 202, 206, which is a safer condition in that you don't have to worry about who's coming up behind me, because if somebody comes up behind you, they're your neighbor and they're going into the same community. And there is enough width of pavement on 202, 206 to just restripe that to get that left turn lane. We would take it out of the shoulders, which is what they did at the vet hospital. We do the same thing on our side, so that creates, again, a safe location for that to occur. Left turns out of side streets have there's a hierarchy. Through traffic on the main line is at the top. They don't have to stop. Left turns and right turns off of the main road are next. Movements from the side streets are the last to make a decision. So that's how we look at safety. How do you design an intersection to meet the design criteria of the state?
So volume, you're saying, doesn't have a factor, but what about age? Age does, right? Doesn't it a higher? I'm just, I mean, the stats.
I'm not trying to be flip.
No, I understand, but the stats in general, right? I mean, they do tend to indicate that it's a higher fatal crash per mile rate based on age brackets, correct?
I haven't studied, I'm not an accident expert. I know how to analyze specific data. I don't look at broad demographic stuff. That's not my area of expertise. Yes, as you get older, your reaction times do slow down. And one of the things that we did is we typically design stopping sight distance. And what stopping sight distance is that I pull out of a side street, my car dies. Does that vehicle that's approaching in either direction have enough time to stop before I get hit? The answer is yes. It's a safe intersection because that vehicle has time to stop. Now, any sight distance that we reference, the traffic engineering profession, that we reference and use from the design guidelines, federal design guidelines, is based on a wet roadway. It's measured on nights like this, when the road is wet. So if they can stop on a wet roadway, we have enough. The comment we had received in the review was that we should use intersection sight distance for this location. Intersection sight distance is longer because what it presumes is that the vehicle on the main line does not have to come to a stop. All they have to do is modify their speed by some percentage, and that vehicle that comes out of the side street and accelerates away, they're not going to catch up to it. So I believe in the sight distance testimony, the analysis we've done, because we more than meet intersection sight distance, that also provides that cushion that makes me comfortable that an older driver has more than enough time to make a decision to either pull out or wait until that vehicle passes.
What's the site distance that you're talking about? How many feet?
610 feet, and that's based upon a design speed of 55 miles an hour. The road's posted for 50. The design guidelines say you add 5 miles an hour to that for design purposes.
You need 600 feet to avoid an accident.
Well, to not have to slow down significantly as that car pulls out. I only need 495 feet to come to a complete stop on a rainy night like tonight.
I've been living in Bridgewater for over 30 years, and it seems that people jump out of side streets, and I got to hit the brakes almost quite regularly. So I don't know what town you live in, but I live in Bridgewater, and that's what I see.
Well, I work in Parsippany.
Okay?
I worked in Bridgewater for 4 years. As I said earlier, I can't, as a design professional, I can't account for somebody making a bad decision to say, you know, I'm just going to pull out because I feel it's my time to go, and they pull out in front of you. Call it what you will, driver inattention, driver error. That is well, that too.
Dovetailing a little bit on that, you know, if we were to just have a, you know, right only, and we were to, Mr. Michello was designed some curb cement like he did with the Starbucks case. He's a talented guy. I know it's safe, and I hear your testimony, but boy, it would really take away some potential problems that could creep up with drivers, I'm trying to be careful here, that are in excess of 55 or older that would be in residence at this facility. You know, this board, I think I've been on it since 2014. I think we have a track record of safety that's pretty impeccable. And I think when you can assure the board it's safe, even though it's not required.
I think that artificially forcing somebody to do something that is not necessary is going to create some other issues. You're going to get people that, because the road is so wide, you can I agree. Mr. Michello is very talented.
Yeah.
He can design it, but unless you put a barrier down the middle of the road, which the state will never agree to,
I know.
you can't prevent somebody from making a left, and then you're going to move the problem down to where somebody makes a U-turn or,
I'm not going to record. I'm just going to put on the record that if you had a right turn only to get onto Foothill Road, you simply go down not even a half mile to Allen Road, and you're achieving the same result onto Foothill in a safer situation. To go north on 202, 206, you'd make a right, and then a right onto Talamini, and then a right onto Country Club. Remember, 3 rights is a left. So you go north on Country Club, and it dumps you out right in the middle of Bedminster. Again, it's a safer result and a less traveled road. I just think it's a good thing to do. Now, I hear your testimony loud and clear that you're testifying that it's a nominal increase in traffic. But to simply do this, and I don't think it would fall on the police for enforcement. If you create some curb that's designed to move the traffic to the right, put up a sign, and we hope for the best. And at least we are appealing to people's common sense to avoid making a left into a dangerous intersection. And I have offered up, I've been a customer of the vet for a long time. I was there at 1 o'clock today, just to kind of prove this point. It's a C level of service, as you claim. It feels like an F every time I'm in there.
To add to Mr. Foos's point, Chairman Foos's point, on the way here, I had to hit the brakes real hard because somebody stopped trying to get onto Foothill Road with no notice. So that area, you do see people do that pretty frequently.
You just take away the safety component that this board, I think, really falls back onto. And, you know, to offer this up and to tell residents, okay, it's going to cost you an extra 10 seconds to get onto Foothill. You're going to have to go down to Allen. I think you could probably get up to Bedminster faster on Country Club than you can by making a left outright. Just throwing it out there,
They
Mr.
choose to
Keller.
do that, but at other times of the day,
You're right.
I
I'm
understand the board's position.
Yep.
This is mine as a professional, having, prepared traffic studies and done analyses for over 40 years, so.
I think a stoplight would be the best result, but, we're not going to be able to get that from the state.
You want a foothill road.
I know, I hear you. All right, I wanted to put on the record, if you want to ask your applicant, if he's saying no, he said no to everything else, I don't know why he wouldn't say no to this, so, that's a no, sir? Okay, thank you. And I guess I'll just add to that a little bit, that, this board, we always try and find yeses. I think that's our job, is to work with applicants to find yeses, to find safe solutions. We've always tried to find yeses, and every time you say no. So, I just want the record to reflect that, for a year and 3 months, we've been hearing this case. You've changed the number of units, you've changed the designs. Here we are, a year and 3 months later, trying to get to a yes. So,
Well, I would say that the generalization is, in my opinion only, not warranted, but I'd put that on the record.
certainly.
Let me ask one question. If you had a no left sign, would that have to survive DOT scrutiny?
Oh, yeah.
What was the question?
Said if you had a
would
no
have to
left,
approve.
left turn, would DOT have to look at that and approve it?
They're going to have to approve the left turn into the facility anyway, right?
They're going to have to approve the access, period.
Right.
Every aspect of it.
Okay.
Okay, any more questions?
Any more board questions? Board professionals? Maurice, good evening, sir.
Good evening, Mr. Keller. As you could see, the board is very concerned about the safety of the corridor, the safety of the intersection, and the driveway. You testified today that there is good sight distance. Earlier, you said there is more than 600 feet, and later on in your testimony, you indicated that the required intersection sight distance is 610 feet, which is correct. And then in your August 12, 2025 letter, you indicated something along the lines that there is more than sufficient sight distance available.
Correct.
However, I haven't seen any plan that shows that sight distance to be available. The only plan that I've seen is one, and I'm looking at it as we speak, that says there is 542 feet of sight distance to the left and only 500 feet of sight distance to the right. And at the last hearing, I asked the same question to the site engineer, and we haven't seen any engineered document, any scientific proof that the sight distance is indeed 610 or more than 610. Can you help us understand this?
Yeah, I mean, I read the transcript, a portion of the transcript from the August meeting when Mr. Michello testified. I don't remember what exhibits we had when I was here a little over 12 months ago. We had prepared, and I thought it had been submitted, and I know you weren't the traffic consultant at the time, submitted a revised site profile document that was revised as of October 22 of 2024 that showed the intersection site distance that was required. I have a copy of it. I brought it with me. It's,
Can you tell the board, because the plan I'm looking at is dated October 11, 2024. Can you point to the plan you're describing and read to the board the information from that plan regarding the site distance?
Certainly. Glad I brought it. So this is a plan prepared by Gladstone Design. It's entitled Site Distance Plan and Profile. It carries a date of October 11th with a revision to October 22nd, 2024, and it says revised per traffic engineer's comments. So from the site driveway, looking to the north, we showed a sight distance of 671 feet. It actually is longer than that. It's about 800 feet to the crest of the vertical curve on 202, 206, north of West Foothill Road. But we stopped at 671 feet because there was no reason to go further. To the south, going down towards Talamini, we showed 610 feet of clear sight distance. Again, we could have gone further, but we met the intersection sight distance of 610 feet, so we stopped.
Can you,
I'm sorry, but I just want, for the record, are you referring to A5? Is there a marking on that drawing?
I just printed this out because I
What was the date of it?
it's
5, right?
It's A5.
it's A5.
By date, it's A5.
Thank you, Mr. Aller. I swore that I testified to it, but I testify so much, I forget.
I didn't have that revision.
And a year
date
has
with
elapsed.
that date, so.
You testified November of 2024 on this?
Yes.
Gotcha.
so if you look at that plan that is revised, I believe you said October 22nd,
Yes.
and you look at the sight line, and then you look at the profile of the roadway or the area next to the roadway. At one point, the exhibit shows a 3.5-foot distance between the profile and the sight line, which is adequate.
Correct.
But then, if you move to the right and you go to station 178, for example, you will see that the distance between the sight line and the profile appears to be about 2 feet. Are you aware of that anomaly or that deficiency?
Well, that's not a deficiency. As long as you have clear sight distance, you don't need to maintain 3.5 feet. Driver's eye is at 3.5 feet. The object height is at 3.5 feet. And as long as there is no obstruction between those 2 points, 3.5 feet for the driver, 3.5 feet for the object, and the existing roadway, then that is not considered an obstruction.
Well, that is not totally correct. If the sight line, and there is a certain tolerance that we need to adhere to, if the sight line is, let's say, an inch from the profile, that becomes not a good situation. Normally, we would like to see the 3.5 feet maintained throughout. What I'm trying to explain here, Mr. Chairman, is that as you're looking towards the oncoming traffic, and the plan does show, I haven't seen these plans, but I'm taking Mr. Keller's word for it,
In the record.
that you do have 671 feet on one side. When you take the sight line of the 671 feet, the pavement and the roadside features that are under that sight line, they go up and down. And at one point, they go up a little close to the sight line, which means that if there is a little mistake, if somebody's not maybe tall enough or the car is not high enough, that sight distance could be compromised. Now, I have to admit that from what Mr. Keller testified to, he does meet the standards. So I have to admit to that. He does meet the minimum standards, but he does not meet the, let's call it the desirable standards. And the reason...
I disagree with that, so.
And the reason I think we may need a higher standard here is twofold. One, we do have a safety history along this corridor of the highway, even though, like Mr. Keller said, they don't relate to the driver location particularly, or at least only 2 of the accidents do relate to the driver location. But we have a pattern of a safety issue along this corridor. The other reason is that this facility is intended for people that are older. And older people, they do suffer from visual acuity. They do have a slower reaction time. So when we design for older people, we design to the highest standards. Again, I don't want to mislead the board. What he presented to us does meet minimum standards. So that is, so I'm going to move on to my second question. If I'm not mistaken, Mr. Keller, the driveway on Route 202, 206 is in a 100-year flood hazard area. If that's true, then...
That's a question you should have asked Mr. Michello.
Well, maybe Mr. Burr can help us, but that's when I looked at the plans and I looked at some available plans online, I determined, I'm not a water engineering engineer at all, but I can read plans, and I saw that the location is in a 100-year flood hazard area, which makes the installation and the operation of an emergency roadway very critical. And earlier this evening, we heard from your attorney that there will be provisions for an emergency access, but we haven't heard any details about it. Can you tell us more about it? Can you tell us where it's going to be, how it's going to operate?
We went over this last year. There's an emergency access between this project and the JCC. The discussion tonight was about providing an accommodation for some existing homeowners who have, from what I understand reading the transcript, have a culvert that sometimes floods. And this gives them, if this project is approved, a way to get out and not have to cross that culvert. But there's always been, I mean, maybe not always, but we agreed to provide an emergency access point between the JCC and this project, which would go to their site and out to Talamini. Having a driveway within a 100-year flood, if that is the case, is it 6 inches? Is it 2 inches of water? At some point when the flood hazard area ends, you have only a little bit of water. I don't know what that is. That's a Mr. Michello question, not a traffic engineering question. So, plus there's going to be, you know, the road has to be designed to meet DOT standards as far as grades and everything else. So that would be probably part of the design associated with that, and maybe in the developed condition, the road's not in a flood hazard area. But I'm not the site engineer, I'm the traffic engineer.
Understood. So, Mr. Keller, I'm going to give you one more chance to say yes tonight. So let's go over this driveway and the movements.
Let me just interject for a moment. Now,
If you could just talk into the mic, please. Thanks.
I talked to the principal of 821, and accepting, as we do, all of Mr. Keller's testimony, we will agree to a left turn prohibition, provided that it gets by DOT.
Understood. So Mr. Michello could design a curb like he did for the Starbucks case where we're trying to push the traffic to the right. I'm sure you recall it because we talked about it for a year as well.
Mr. Michello will have to respond to that.
He'll get out there
I
with
can't.
his trowel and he'll start shaping it for us. All right.
But the concept of no left turns would be okay as long as it's approvable by the DOT.
But you're going to have to come back for a site plan approval if this is approved anyway. So that, you know, that could be part and parcel of the next phase.
Right. But again, maybe we move along from this issue.
I'd like to move along too. Maurice, are you good with that?
I'm good, yes.
All right. Thank you, Mr. Coakley. I appreciate you doing that.
And that's all I have, Mr. Chairman.
All right. Thank you, Maurice. Can I open up members of the public?
Sure.
All right. Members of the public that would like to ask questions on Mr. Keller's traffic testimony, you can come forward now. He's not an engineer. He's not that type of engineer. We do have Mr. Marcello here. If you do have a direct question, maybe towards the end, we could do some house cleaning and we can ask that question to him. But right now, it's just for traffic questions. Hi there, just get your name and address, please.
Rob Esposito, 738 West Foothill. So the dates that were given for the Oprah requests, I have January 2020 to September 24, is that right?
Yes. 1/1/20 and 9/9/24.
And you said 2 accidents in that period?
Correct.
And then the police provided in February 1825 that there was 23 accidents, correct?
Over a much larger length of analysis.
Okay. So do we have the distribution of those accidents, where, like, how many were in the 2020 to 22 and how many were in 25?
From my report, I don't recall when they were. They were spread out over, I don't have the exact dates. I didn't bring a copy of my entire report because my testimony here was going to be limited. I had given extensive testimony on accidents and a lot of other things a year ago.
Okay, because I suspect that majority of them might be in 25 or 24, that during the COVID years, maybe there weren't so many. And if we had extended back to 18 or 19, I think the data could be quite different.
The police went from 2020 as well, so I don't know. But there were only 2, so there's no pattern to analyze. There's no trend you can get out of 2 data points.
Yeah, I also don't know, I personally know somebody that's been in an accident in that stretch, and we submitted an Oprah request too, and it did not come back. I don't know if we're doing something wrong or if there's a trick to it, but I don't know where I think there's more accidents happening than are reported, and I don't know how to justify that, but.
All I can do is ask the police I give them parameters and they give me the reports, and that's what I get. And I rely upon that.
And is it possible, I know you typically do 5 years, but can we not go back to 2018 and maybe all the way up until the present time? Because
This request was done for a report that was written a year ago. So that's why the Oprah request went to September of 24, because that's when I made the request. We could go back, but I don't think that, especially given the discussion tonight and the fact that we're agreeable to right turnout only, that there's really any relevance to additional accident reports, if they exist.
I think there is, not just for the site driveway, but for the whole stretch.
Well, like I said, I went from West Foothill Road, where you live, down to basically the culvert that's in front of the site, because that's where I wanted to collect any accidents associated with the Allsteed Farm Stand driveway. And I got 2. That's it.
Right, but also during, as you said yourself, a very strange period of time, I don't know how we can't acknowledge that skews the data quite a bit.
It has an impact, but I don't think it skews it that much. So that's my opinion.
Okay.
It's an appropriate period of time.
The other thing, I also heard you say that I'm not an accident expert. Is there somebody that we could get as an accident expert to do the type of analysis that everybody's asking for?
Well, accident experts are reconstruction. What caused it? I can read an accident report. I've been doing this for 40 plus years. I've read hundreds of accident reports, and I can pull out of the factors, was it a right angle? Was it a rear end? I don't need to reconstruct the accident to understand, is it a roadway condition or is it a driver issue? So you're not going to get any more information relevant to a land use application than what I'm providing.
Okay. Okay, the other thing, you had mentioned that the main car, when somebody's pulling out, the expectation is that the main car is going to modify their speed to let that car out. Could you describe that, how that factors into the numbers and the level of service? Because
It doesn't.
It doesn't at all. I mean, I completely disagree with the fact that main cars modify their speed in any way. If anything, I think they speed up because they're annoyed that somebody cut them off. They didn't see them pulling out. And I think that statement, it doesn't make it safer.
Okay.
And for the record, I don't know if it goes on the record, but this shrugging and this attitude of I don't care is...
It's not a matter of I don't care. That's your opinion. It's not mine. People, and this is based upon, reference manuals, things that we use to design roadways. It's right in the documentation that an intersection sight distance of 610 feet is based upon a presumption that a driver coming along a state highway doing 55 miles an hour has somebody pull out in front of them, knows that they need to get up to speed, they're going to back off the gas a little bit and slow down. It's not that I don't care. I care a lot about what this is, how we design a project. Many projects, my name's on these plans. In this case, it's not, but I care about what goes on these plans. It's my license at stake. So my shrug is, okay, that's your opinion. It's not mine.
Okay, so everybody that's giving their real life experiences telling you that people pull out on them all the time, I had to slam on the brakes, and you are going like this, what does that mean?
As I said a couple of times tonight, there's nothing we as design professionals can do if somebody decides, as Mr. Bongiorno said, does something stupid. I can't design for stupid. Okay? I can't. We design to make these intersections, these roadways, as safe as possible to provide the drivers with the ability to make smart decisions. Somebody pulls out in front of you, hey, look, I drive a lot too. I have people, pull in front of me and slam on the brakes. I can't design to prevent that.
Mr. Esposito, if I can help you out, you nor I are experts. Even though we drive, and you drive probably more than I do in this vicinity, when a judge reviews this case, if a judge reviews this case, he's going to look at the expert testimony. And Rich, maybe you can chime in here. Experts, on the hierarchy tree of valid testimony, they rank here. Unfortunately, you and I, we're down here, even though we drive it more than these experts have been there probably in their entire lives. So our board has retained Mr. Rashed Maurice from Collier's Engineering, and he basically described his opinion, his expert opinion on the situation. So, as a board, we're just trying to get to what is safe. So it sounds like the applicant tonight offered up a right turn only, which I think is a step in the right direction. I'm thrilled to hear it. Maurice talked about minimum levels of service. These are things that maybe you want to kind of get your questions focused on because you're going to be driving it. And unfortunately, even though we're there all the time, I'm at the vet all the time, I have a 12-year-old dog, we're not experts.
I know, and that's kind of what I'm getting at, is that there's the expert opinion that you cross your T's, dot your I's, and you get approved, but the reality is something different.
And resident, honestly, it's the most frustrating part of being on a land use board is that we're not experts, that we just have opinions. And trying to convince people about our opinions is sometimes difficult when people go spend their whole careers working on something. Mr. Keller truly is an expert. He's in well regard, his license is in good standing. Our board has retained Mr. Rashed, and he's the counterweight to all this. He's the check and balance to his testimony. It sounds like they both agree that it's safe. Now the levels of safety, I'm not going to interpret. I'll let you interpret, and each individual board member interpret that. But I don't want to put testimony on the record for any more than things that I have encountered while being a customer at the vet, because I'm not an expert. So if that helps.
Yep.
No, I think you're completely accurate. Everyone including this board, would rely on expert testimony.
So as much as I say, I'm very frustrated when I go to the vet, sometimes traffic stinks. I was there today at 1 o'clock, traffic was it's never good. But it does meet these minimum levels of safety that we have to interpret that, a judge is going to say, hey, board, you voted on this and you interpreted this, but you're not an expert. You're arbitrary, you're capricious, et cetera. It really nullifies our power in this case. We really want to lean on what experts have to say. And I'll give you as much time as you want if you want to question either one of our experts on traffic.
No, I'm good. I mean,
All right.
yeah.
I hope that helps. I wish I could do more.
No, that's good. Thanks.
You got it. Thank you, Mr. Esposito.
Mr. Chairman, do you mind if I ask a question of Mr. Keller?
Of course, please.
He had just said something in his response about, only being able to design the roadway based on, its configuration rather than driver error, right? Rather than people driving
I think
stupid.
he said you can't design out stupid. Yeah.
Yes, and I just wanted to double check because I brought up the traffic report earlier about the details related to the one accident, the one incident that happened, I think, in 2024. It did include that there was a car stopped in the northbound shoulder, which caused a visibility issue when someone was making the left out. And that's why the driver came around that car and hit the car that was making the left out of the vet hospital. And I just had a question, I guess, related to configuration about, is there any issue with the configuration, noting that with the shoulder and the additional turn-in lane that's going to be reconfigured and restriped? Are there any concerns about traffic in light of that?
I mean, I don't recall the specifics. I didn't reread the accident reports, the two that they gave me for tonight, because I wasn't anticipating questions on that. But if there was a vehicle stopped on the shoulder, that is not a normal condition. There's no parking permitted there for whatever reason that vehicle stopped. Somebody made, as I think you put it, Mr. Maude, driver error. They made a mistake. They should have, been more careful in pulling out in that situation. But, it's better to have a shoulder than not to have a shoulder.
Is there any significance to the fact that there were two crashes and they happen to be exactly at the same driveway where it's proposed to be aligned with? Is there any significance to the impact on this project?
No. 2 accidents in 5 years?
No, I just mean in relation to the fact that you sought an OPA request for different intersections adjacent to this property, and they happen to be exactly where it's aligned with, proposed to be aligned for this project. Is there any significance to that?
No, I don't think so.
Okay. Is there any other, have there been any other configurations of the driveway as far as moving it further south, away from the Foothill intersection?
I think that would be we considered other options, and I think, given the type of roadway we're intersecting with, and trying to meet the required separation, and I don't remember the specifics, moving it further south puts it closer to the culvert, puts it into...
I mean more, less of the environmental concerns. With the driveway...
You can't just say, I'm going to...
No,
environmental concern.
I mean...
The best place to put this is where we've put it, to create 2 driveways that align with each
So
other.
this is the safest place for the driveway to be
Absolutely.
located, regardless of the environmental conditions on the property. Okay, I just wanted to make that clear.
Yes.
Thank you.
Thank you.
Mr. Chairman,
Yes.
I want to ask a question as a follow-up to what our planner is saying. If you move that driveway a little bit towards the south, it would be similar to what we have, on that property. They have like a business there. They sell fruits and whatever else, plants and all that. And their driveway is a little bit to the south. And this would be something similar in that location. The present location has a driveway that goes in there. Would that help? Because,
I don't, just because the driveway is there today doesn't mean that it's in a good location. It's just that it's there. We try as engineers, when we design a new project, design something new, to look at it fresh and go, where should this driveway be? I mean, in hindsight, their farm stand driveway should be where we're putting our driveway. But it's not. It's there, it's probably been there for 50 years. So, yes, it's there today, but I don't think it's a good location.
So now my question is, because a lot of customers go into that property because then they slow down and go in there. And during the daytime, you see quite a few people go in there. So it would be similar to this, people who are going into that property.
But I don't think that's a good location for
Location,
driveway.
yeah,
I mean, yes, they
right.
do it today.
It helps because it's far away from the veterans, the driveway that goes into the Veterans Hospital is right
I'm
across
sure
from the
farm stand
proposed.
was there before the vet hospital. I don't know for sure, but I have a feeling it was, because that property has been used as, whether farm stand, agricultural. But the bottom line is, the driveway, from a design perspective, is proposed in the best location that's shown on these plans.
The safest location.
Safest
Gotcha.
location.
All right.
Yes. All right. Thank you, Mr. Chairman.
Thank you. All right. Member of the public, please, just need your name and address.
So I understand that the traffic is all going to be directed to the right, which means that it's a lot more traffic, which is going to affect me. I'm 2 driveways away. And I was wondering if anyone thought about the people who live along that road and the impact of
Testify to how many trips per day there's going to be here. I think you need to.
Per hour.
Yeah.
Because right now, it's difficult to get out of my driveway, either to the right or the left, and it's scary getting into my driveway. And there have been accidents, a lot of accidents, where cars have wound up in that creek while I've lived there.
So could you just phrase that in a question for Mr. Keller?
So has that been addressed?
So, based upon the discussion tonight, we had, there will be 28 vehicles exiting the site in the morning, and they will all be making a right-hand turn. And which is 13 more than we had calculated in our report. And that is about 3% of the existing traffic on 202, 206 today. So it's anything less, 3% increase in traffic is nominal. Yes, I can understand. You
Yeah, I
live on a
live
state
there.
highway.
I live there, right.
It's a busy road. Nobody's going to dispute that. There's going to be a couple more cars than what we had anticipated.
Are you the resident that testified at the last meeting about the flooding that took out your access?
Yes.
So you get some benefit here.
I thought I couldn't ask about the flooding.
I'm just pointing, I'm just pointing that out, that Mr. Cohen at the beginning of the meeting offered up that they're going to allow you to use the emergency access that's going to be created with this site.
And so my property and my neighbor's property is going to hook into that road?
Sounds like from what Mr. Cohen said, it sounds like.
I'd like to see that because,
Only in an emergency, not on an everyday basis.
I understand that, but I'd like to see how that's going to work.
I don't know.
Okay.
That's
Yeah,
not,
that wasn't
When
part
will
of
we
his
know?
testimony, but there is an exhibit. When we take a break, someone can find it for you to show you where the access way is proposed.
Okay, because I would like to see that during the break.
Any more traffic questions?
Yeah, I mean, I'm concerned. As a person who lives right next door to them, I'm concerned about getting in.
This is
When-
questions only, though, please.
When you say next door, are you closer to Talamini Road or are you?
I'm in between what was Linda's Farm Stand and Gray's Florist. There's 2 driveways. I'm one of those 2 driveways. And there are a lot of accidents when people are, when I'm trying to get into my driveway.
It's question time.
Yeah. Well, I'd like, so that hasn't been addressed
What?
or thought of.
What?
How
I
it's
don't know
going-
what the
how it's
question is.
going, how the increase in traffic is going to affect the property owners there.
Adding 13 more cars to the flow that is already on 202, 206 is not going to materially change the level of service for you trying to get out of your driveway
Or into my driveway.
or into your driveway, correct?
I disagree. Okay.
Anyone else? Questions for Mr. Keller? All right, seeing none. Thank you, sir.
Thank you.
A5. Nancy, do we have a copy of A5 in the office? We must, right?
A5 was marked at an earlier hearing.
In November.
Or,
Yeah.
yeah.
If there's no physical marking on there, you can take that. Yeah.
Yeah, I heard it is fit.
We're good.
Okay, thank you.
Sure. And Mr. Coakley, you sent the letter to the board, and we all have a copy of that. And this testimony is related to that letter?
We sent a copy of his report that he submitted to the
Right, with-
Affordable Housing Court.
Gotcha. So that's the October 22nd, 2025 letter.
Yes.
Thank you.
All right, Mr. Steck, you testified previously in this matter?
I did.
And I will swear him again.
Okay.
It's been a while, too. So, Mr. Steck, would you raise your right hand? Do you solemnly swear that the testimony you will give to this board will be the truth, the whole truth, and nothing but the truth, please?
I do.
And would you state your full name for the record, please?
Peter Steck, S-T-E-C-K.
Thank you. Mr. Coakley?
Mr. Steck?
And my license is still in effect, in case you were wondering.
Still in good standing, you mean?
Yes.
Okay.
So when you testified previously, it was regarding the use density variance application. Is that correct?
Correct. There was a use question, there was a density, there was an FAR question also.
Okay. The use variance is the driving element of all this.
It's kind of the parent variance here, and we were addressing a D1 variance for both the JCC as well as the townhouse proposal.
Okay. And at that time, when you testified, there was a 60-unit plan that was being discussed. Is that correct?
Correct.
All right. And now the plan is 64 units,
Yes,
of which 13 will be affordable. Is that correct?
that's correct.
All right. Is there any change in your testimony about the variance or anything related to the variance based upon the changed number of units?
There is not. The changes that have occurred, the subdivision line shifted slightly, and again, this is the bifurcated concept plan. Subdivision line shifted slightly, but essentially 3 acres are going to go to the JCC with no change in intensity. Again, the number of units went up from 60 to 64. The affordable units are now going to be built on-site. So the density proposed now, it was 5.03, and now it's, I think, 5.37. The FAR went down slightly. In my opinion, none of these changes compromise the testimony that I gave last time, that the variance requests meet the statutory criteria for both the positive and negative criteria for approval.
So did you prepare a report for the Affordable Housing Court? I'm going to call it that. I don't know whether that's the right name or not.
I did.
And what did that report say as it relates to this property?
Yes, I was asked to address Bridgewater's fair share plan that was submitted. And in short form, the conclusions I reached is that this site that we've been speaking about this evening meets the suitability criteria. It is available, approvable, developable, and suitable I also noted that your fair share plan is required to reference developers interested in producing inclusionary housing. This development application was not referenced in the plan. And also, the property was not referenced as a potential site for additional housing, whether it's single-family or multifamily or townhouses.
So you're,
Mr. Coakley, what does this have to do with this case? I understand where you're going with this. I just don't know how this helps the board come to any decision on any of the use variances that are proposed tonight. And I know you filed suit against.
grounds of a use variance, I mean, there's several grounds
Mhm.
of advance, but one of the grounds is that affordable housing is a community good.
Excuse me, I can't hear you.
One of the grounds that has been advanced, in addition to the age-restricted nature of the housing, and in addition to the fact that this use is particularly well-suited for the site, but also that this is a affordable housing use, which is, by the law of New Jersey, iterated over and over, is a community good. And so he's basically putting forth to the board that this is a community good. This site is available and desirable.
You're an aggressive attorney, and I mean that in the biggest compliment. I just wanted to make sure you weren't using this as a forum for your lawsuit against the Township of Bridgewater. But based on that explanation, I'm willing to let this continue. Thank you.
All right. So I don't know where I interrupted you, if I did.
I'll just repeat my conclusion that from my initial testimony, there were changes in the application. I consider the changes not at all compromising my original opinion that the statutory criteria are satisfied under the Medici standards for both the JCC as well as this development, and the negative criteria are fully satisfied. In other words, it can be approved without substantial detriment to the public good. That's things like traffic and stormwater runoff, and will not substantially impair the intent and purpose of the zone plan and zoning ordinance.
All right. Just so Mr. Cohen doesn't jump up and pop me one, what would you say as to the negative criteria as to the JCC use?
If you recall, we are going to be expanding their site by 3 acres, but it's not changing the intensity of its use. Its use has been recognized as an inherently beneficial use. It certainly stays in that category, and if you review it either under the Medici standards or the SECA standards, in my opinion, it meets the statutory criterion.
No further questions.
Thank you, Mr. Coakley.
Can I go back just for a moment to when you were talking about the letter that you submitted, that Mr. Steck produced, based on the challenge to the housing, the fair share housing plan that Bridgewater has put forth. I'm still not clear as to the purpose of your inclusion in that, or is it just an FYI challenging this use, or is there a purpose that goes beyond that?
No, our purpose here is basically to explain to the board that we have an affordable use that's highly complementary to the standards for affordable housing, and that the board should take that into consideration in deciding this case.
And that request that you made, or challenge that you made to the Bridgewater's fair share housing plan, has not been adjudicated? There is a conclusion?
It has not been adjudicated.
So you're hoping for a result based on your submission that you explained?
Yes.
And if that were resolved to be positive, then perhaps you'd have some reason to pursue legal action against the township. Is that true?
No, we're not contemplating that at all. It would obviate the challenge to the town's affordable housing plan. We'd have no basis to challenge it, no standing. If
No, I'm saying, absent a decision on this project, if in fact you were to move forward as you are progressing, isn't that the intent then, to say that I'm challenging your fair share housing plan, and as such, I'm going to then sue the township and see what happens?
we have filed this action against the township challenging the affordable housing plan. It had to be filed by August 31st as a matter of law, and so we did that. There was a hearing held, and there were some questions asked, and we were advised by Judge Miller, who was handling the case, to call him up after the next hearing and tell him whether we got the variance or not.
So you're using...
I'm not using, I'm just trying to...
I'm trying to understand it, so bear with me, I'm not an
Okay,
attorney.
I'm sorry, I apologize.
It's okay. We're just having a conversation right now, and I'm trying to understand as best I can so that everybody here understands it as well. That's my intent. But it appears to me that, so you have this letter, and you're letting us know that this challenge has been made. You're now saying that the judge is saying that if, in fact, the project were approved, then the lawsuit goes away, and it feels like you're leveraging this board inappropriately, at least that way to me.
I don't think so. I mean, we had to file the challenge to the plan by August 31st.
Yes.
Which we did. The Judge Miller and his judicial apparatus there would like to see that case resolved. I mean, that's my opinion. Every case I'm in with affordable housing, they want to resolve it.
Yeah, John, I wasn't involved, I'm not involved in that case, and Catherine's not the affordable housing planner for the town, so I don't think you were there either. But, I'm not sure it was really a hearing as much as a settlement conference on your case.
Right, the hearing is scheduled for December 5.
Right, so my understanding was that since this matter was pending, that Judge Miller just kind of called a timeout, if you will, and said, let's see how the case proceeds, and then they'll take some action based on what the board does later. And I think the lawsuit is to be included in the fair share plan. Is that right?
Yes.
Right?
In a big general way, yes.
Right?
And my opinion is that I don't think that that should have any bearing on the board's decision tonight as far as what's going on with the Affordable Housing Dispute Resolution Program. That's a separate...
That's why I brought it up. It
Yeah.
sounds like Mr. Coakley was just trying to get to the heart of, hey, this is affordable housing that meets a lot of the criterias, and then he brought up the inherently beneficial. Now, I mean, I think we're eating up a little bit of time here. John, I don't want to step on your toes.
No, not at all. I just wanted to understand. I do now, and I appreciate your response.
Okay, thank you.
And Mr. Coakley's not using this as a forum for his lawsuit. He's just pointing out that this is a inherently beneficial use.
I mean, I would recommend if this variance were to be granted, I would call Judge Miller up tomorrow and say we're withdrawing.
Yeah. But I want to point out, affordable housing is not inherently beneficial, right? The JCC use is inherently beneficial, and then the SECA standard would apply for that, but affordable housing is not.
No, there are case laws about affordable housing senior projects being inherently beneficial.
Yeah, but I don't think that case says they're inherently beneficial. I think it says the opposite.
I think it does. No, the case that I'm thinking of, it does.
Yeah.
But Mr. Steck, you're not testifying that the housing component is inherently beneficial of this case.
The inclusionary component at the 20% level is not automatically inherently beneficial.
Thank you. That's all I wanted to make sure. But of course, Mr. Cohen's.
Post-trip on that, but on a case-by-case basis, the court in the appellate division has held just recently that the court should consider all of the elements of that presentation in deciding whether that use might be inherently beneficial.
The big change was that we are now including affordable housing units in the project. That's a major change, which obviously has some public benefit to it.
That was the one thing I was just curious about, because I remember in the first couple of hearings, you were actually very adamant that you were not including affordable housing in this project, and that your preference was to pay into it, and you had no interest in affordable housing, and that was something that changed.
Not exactly. We were suggesting that we were willing to subsidize affordable housing.
Right. You didn't want to build any units.
But we were willing to
pay
for a subsidy. As the hearings went on, it became clear that that was not an acceptable answer to the board.
Right, I just want to make sure it's clear. In the beginning and up until, I guess, the last meeting or right before that, there was no interest in
This
building.
board has been advised, and Rich and Catherine, please
Yeah.
chime in here. This town cannot accept cash in lieu of actual housing
Right.
units. Yeah.
Yes, that was my interpretation of the ordinance as, you know, plain,
And
the
our
plain letter.
affordable housing attorney has advised us the same.
Correct.
Right,
And here we are.
all right.
Mr. Kulak, you good there, sir?
Yes, thank you.
All right, thank you. Any other board questions for Mr. Steck?
I have just one question. Regards to the affordable housing, there's 13 units proposed, brings the total unit to 64 now. Just in terms of a planning perspective, I'm looking at the overall size of that structure with the 13 units and kind of looking at the remainder of the units. I mean, it looks like 13 units are the same sort of, at least footprint area of 5 units that you're proposing. In terms of affordable housing, from a planning perspective, how do you kind of measure kind of the size of such units with compared to neighboring units, right? Is there some sort of...
Because this is age restricted, these are all one-bedroom units, so they're smaller. First of all, keep in mind, this is a bifurcated application, so in terms of the details of the design, not in cement yet. We are
Right.
asking for the use and the intensity. When we come back for site plan approval, you have the ability to introduce your opinion about the arrangement of the units.
Okay, no, I understand, but it also does impact in terms of the variance you're seeking. You know, it's 64 units that would be approved as part of this. So I think the idea of, you know, you need the units that are 1/3 the size of a non-affordable unit. That's
There are
kind of the question.
regulations that this will be subject to, where they call them the UHAC regulations, about distributing units, and that will have to be addressed if it's approved at this stage.
Okay.
And Mr. Vestio, just to, you know, give a more detailed answer, the current UHAC regs that are in place right now actually do stipulate certain requirements for unit sizes as well as unit type. Right now, the plan that we have that shows the affordable units is not compliant with the UHAC regs. It actually does require the same unit type as the market rate units. So if these market rate units are townhouses, then the affordable units also have to be townhouses. So it does have an impact, you know, to your point, it does have an impact on how the site is laid out because those units will have to be distributed as townhouse units to meet the UHAC requirements.
Yes, that's exactly the point I'm trying to get to. It's like, we're approving 64 units, or that's what's being asked of us. I don't really see much more open space here to put additional units. And if we kind of take those, what I'm saying, equivalent of 5 units, and expand that to 13 units in sort of in area, you know, where does that go, right?
Well, this is still, in terms of your master plan and in terms of state law, this is low density. You're under 6 units per acre. This is, you know, 5.37 units per acre. And again, the applicant has intentionally said we're bifurcating the application. So the arrangement of the site, even though there's some engineering things that won't change, we've already tried to demonstrate that that driveway is in the safest location, so that's not going to change. The floodplain area isn't going to change, nor the riparian area, but there can be manipulation of the site plan to accomplish mutual goals.
Okay. And I think part of the approval that's being asked for is the FAR as part of our approval. Right, so that could not be increased from what is currently proposed.
Well, it's subsumed, you know, as you know, the FAR in your ordinance was intended for single-family detached homes. So the focus of this is on the use variance, and the other variants, I would suggest, are somewhat subsumed into it. You can say, oh, 45% is so much larger, you know, than whatever 12% what it was. But again, your standard was intended for single-family detached homes, and that's why the parent variants here are the use variances for both JCC and this multifamily / townhouse development.
Okay, but if I understand this, the ask is 42% FAR.
That's what the current plan shows.
Okay, so, thank you.
Any more board questions? Board professionals?
Mr. Vestio took my question, so I think that I have nothing further for this witness. Thank you.
Just have one question, Mr. Chairman. Mr. Steck, I think you hinted earlier that you may have only testified one time prior. You've been here twice, right?
I testified and then I came back for cross-examination.
And when you were here in March, you testified to the 60-unit proposal, correct?
Yes. Well, actually, as you know, it changed over time. It was 64 and 60, but...
And then when you were back in May, it was 52.
Yes.
And now tonight,
So-
you're back up to 64.
Yes.
But your conclusions, what you're testifying to is that you believe the statutory criteria is met for any of those number of units.
That's correct. The current 64 is the highest number of units that was ever proposed on the site, if I recall. So I'm covering all bases because at one time it was just 60 units.
Thank you.
All right, members of the public, questions on Mr. Steck's planning testimony? All right. Just get your name and address again, please, for the record.
Rob Esposito, 738 West Foothill. I just had a question. I was looking at the document where it describes the housing plan as being defective for the affordable application. And I was just wondering why it was not considered initially. What makes it defective?
I'm not sure I understand your question. What do you mean by initially? When the application was filed, initially it did not include housing on the site, and there wasn't a recent fair share plan. As this application proceeded, there were changes to the plan, number one, but also the municipality filed its fair share plan, and the applicant exercised its rights under the kind of the negotiation process in this affordable housing round.
Okay.
And so I was asked to participate in the plan review.
Okay.
The
So maybe-
plan meaning the fair share plan review.
Okay, and maybe it's the legal language that I'm not understanding, but I see the Bridgewater Township's 2025 housing element and fair share plan is defective in that it ignores lots 45 and 46 in block 477 in its projection of the future housing stock. It ignores the interest of 821 Bridgewater LLC in providing affordable housing, and it fails to recognize the 11.9 acre portion of the site as suitable for the production of affordable housing, and more specifically, its suitability for age-restricted affordable housing. So I'm just trying to understand, in layman's terms, what that means. What was wrong with the plan? Why is it defective, and why does it need to be modified?
Again, this is different from the application, but the answer is there are certain standards in the law about what should be in a fair share plan. And for example, you have to reference developers that are interested in producing housing.
So did they not do that?
They didn't put the name of this developer in.
Why? There was no interest at the time, correct?
Again, this has nothing to do with this application, so I think we need to go to your next question.
It does, though, because it's being pitched, the affordable housing has shifted the whole project.
No, it hasn't. There was always affordable housing component with this project, right? It just was a matter of, was it going to be built on-site, off-site, or a contribution, right? So initially, they came to us and said 52 units or whatever it was, and we'll build off-site. Contribute, so that the town can then build off-site, right? We said we can't do it that way. They've eventually come back and said, okay, we're going to put the affordable units in the same project, right? And integrate them in the buildings with the market rate units.
So what happens if it doesn't get approved for affordable housing?
Ask Judge Miller.
Yeah.
Sorry?
Ask Judge Miller in
Yeah.
Somerville.
Then they're going to proceed and try and get it into the plan somehow.
Okay, but it doesn't change the board's vote?
Correct.
Okay. All right.
Rich, I would just clarify that there was always a requirement for some sort of set aside, whether it be
Right.
monetary or otherwise. And it wasn't until August that we saw a plan that showed a physical set aside of the units. I just want to clarify that.
Thank you. Any other members of the public? All right, seeing none. Thank you, Mr. Steck.
Thank you.
All right, Mr. Cook, can we take a quick break before we continue? It's 8:46. Why don't we take 5 minutes? All right, we'll see everyone at, let's call it 8:52. We'll reconvene. Thank you.
Chairman Foose.
Here.
Mr. Wadley.
Here.
Mrs. Amin.
Here.
Mr. Sweeney.
Here.
Mr. Fresco.
Here.
Mr. Bongiorno.
Here.
Mr. Gieske.
Here.
Mr. Seek. Sorry, he's absent. Mr. Kulak.
Here.
Mr. Vesio.
I'm here.
Mr. Gabbett.
Here.
And I just want to clarify for the record, Mr. Rashad was not called in the beginning.
He's definitely been here.
Definitely been.
Yes. All right. Thank you. All right, Mr. Coakley. All right, how about Mr. Cohen? Would he like to make a final summation?
But we have to open to the public.
Yeah.
too.
Yeah.
I said we do have to open to the public.
Want me to do that now?
Yeah.
Okay.
Then they
All
finish
right,
with them.
members of the public that would like to speak for or against this case, I'll give you the microphone. If you please come forward. We got about an hour left, so if we can get them all in tonight, that would be great. We just need your name and address for the record, sir.
Good evening, ladies and gentlemen of the committee, Mr. Chairman. Thank you very much for giving me an opportunity to speak tonight. My name is Peter Saccatelli. I live at 826 Route 202-206. I'm the home.
Kelly, would you raise your right hand, please? I have to swear you in for your statement. Do you solemnly swear that the testimony you will make to this board will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir.
My home is 826 Route 202-206. I'm the home directly across the street and one of the people most impacted by this proposal. I've lived in my home for the past 25 years, and I'd like to think that I'm somewhat of a pillar to the community. I own a small landscape design company here in town, and we give back to this community as much as we can. A couple of quick examples. We've been cutting the grass for free for the Visions and Pathways homes for the past 21 years. We've been cutting the grass for free for the Green Knoll Rescue Squad for the past 20 years. They were really kind last year to put a note on their front sign for us, thanking us for our dedication to them. We've been cutting the grass for free for the Green Knoll Fire for the past 17 years, cutting the grass for free for the North Branch Fire for the past 13 years. We're also involved with Green Care for Troops. Green Care for Troops will call us when a local soldier gets deployed overseas. We'll go in and we'll take care of that soldier's property for them until their safe return. This past year, we were taking care of 2 local soldiers' properties until they got home from overseas. My precious view is in jeopardy. Right now, when I look across the street, I see a beautiful wooded lot and a charming farm stand. Farm stand actually that has been part of Bridgewater's history for the past 50 years. Maybe I'm a little bit impartial to the farm stand because it is across the street from my house. There's nothing better than being able to walk across the street and picking up some fresh produce for dinner. Not to mention that they make a really good apple pie, but my actual favorite is their peach vinaigrette dressing. I feel like the farm stand, maybe it's not a very important point, but to me, it's an important landscape of Bridgewater, and I worry that Bridgewater is losing its charm from overdevelopment. It's really nice to drive down 202-206 and see this. Also, with the thought of putting in these 64 units, I'm a little concerned about the animals on the site. I'm sure with my neighbors, my home has become inundated with deer throughout the years, and with the development of this 16 or 18 acres, I couldn't even imagine how many more animals are going to be living on my front lawn. I wanted to talk a little bit about traffic. I'm no traffic expert, but I do live on the highway, and I've watched and experienced the traffic there for the past 25 years. When they talk about 64 units, I would say probably with 64 units, you're assuming there's going to be 2 cars per household. That's 128 more cars that are spilling onto this roadway on one small driveway. I know when I'm on my driveway trying to turn left, especially during peak hours, it could be frustrating. It takes time. Mr. Chairman was talking about they would be allowed to make a right, but that's going to make it even more difficult for me to get out of my driveway. So I don't really understand when they say that there's going to be a nominal increase in traffic. The farm stand has 8 parking spots. Most of the time, those parking spots are not completely full. There's maybe 4 or 5 cars there. We're talking about 64 units with probably 2 cars in each driveway. So you've got 8 parking spots, or you have 128 cars coming out on the same driveway. Again, I'm no traffic expert, but it just doesn't seem to calculate well to me. They did talk about drainage at some point, and I don't remember at what point that they said this, but I had thought originally they had the driveway a little further south, and then someone said that they were worried about flooding, so they decided to move the driveway a little further up north so that it wouldn't be at the low spot, so if we did have a flood, that they could still get out of their driveway. Well, my driveway is at the bottom of this roadway, so if something happens and these 64 units start to flood the roadway, it's going to be me that can't get out of my driveway. I mean, and let's face it, you can only start putting so much blacktop and asphalt roofs without having enough green for proper runoff. The site is not zoned for the use that they're looking for. I personally don't see a reason why the zoning should get changed. I know myself and my neighbors, this is our home, this is where we live. I don't feel it's fair that something should be put here that wasn't zoned for this to begin with. I want to thank you guys for the opportunity to speak tonight. I really appreciate it. And in closing, I just wanted to leave you guys with one question. If this was your home, if you lived where I lived, how would you feel? Thank you. Thank you so much.
Hey, thank you for everything you do for our town, and Visions and Pathways was in front of our board, and they're a wonderful part of our township, and we're lucky to have them and lucky to have you. Thank you.
Thank you. My point was I care about the community, and we do everything we can to try to help out. So thank you.
Yep, thank you. Hi. Just your name and address, please.
Sorry?
Your name and address?
Lisa Ferrara, 788 West Foothill.
Ms. Ferrara, would you raise your right hand, please? Do you solemnly swear that the testimony you will give to this board will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
I live near the proposed rezoning site, and I'm here to respectfully but strongly oppose the zoning change requested by 821 Bridgewater LLC to the 202-206 corridor. This is not a minor adjustment. It's not simply age-restricted townhomes with a few affordable units thrown in. This proposal would fundamentally alter the character and function of 12 acres of R40 residential land. It represents a major upzoning that will permanently change the scale, safety, and future of the corridor. I'd like to focus on 7 core points. First is traffic and safety. The area surrounding this site is already congested and fragile. I live there. I experience it every day. Making a left turn is difficult and often unsafe. The JCC generates significant peak hour traffic from programs, camps, and services. Adding 64 residential units plus an institutional expansion will push this corridor beyond its safe capacity. Everyone who drives this stretch knows how precarious it already is. The second is inconsistency with Bridgewater's master plan. The master plan emphasizes preserving community character, limiting traffic growth in residential areas, and directing high-intensity development to places like Bridgewater Commons and Chimney Rock. Nowhere does it identify 202-206 as a location for multifamily housing. In fact, it recommends reducing, not increasing, congestion along this corridor. Rezoning must follow the master plan, not rewrite it for individual applicants. The third is the environmental risk and inadequate infrastructure. So this site includes steep slopes, wetlands, and a tributary of Peters Brook. Yet the stormwater basins are designed with incomplete data, and key groundwater and recharge details are being deferred to a later date. We can't approve first and engineer later. Added density places new strain on older sewer lines and stormwater systems in the area, already well documented with flooding along 202-206 and Foothill Road. Without major developer-funded upgrades, which rarely occur, these costs shift to taxpayers. And no independent studies confirming that the existing infrastructure can support the proposal. The fourth is significant wildlife disruption and loss of over 400 trees. So this property is one of the last intact wooded areas along this stretch of 202-206. The applicant's own materials acknowledge the removal of more than 400 mature trees. This has real consequences. Deer, foxes, other wildlife already displaced by surrounding development will have nowhere left to go, increasing roadway hazards and residential encounters. Removing this many trees eliminates natural buffers that reduce noise, light, runoff, and erosion. Tree loss directly worsens flooding and stormwater impacts. And it's a problem this area is already struggling with. And once the habitat is gone, it's gone. So Bridgewater spent years trying to preserve tree canopy and protect open spaces. Allowing clear cutting on this scale undermines that commitment and worsens the ecological stress. The fifth is irreversible spot zoning precedent. Approving this density sets a powerful precedent for every other parcel along 202-206. It says that the master plan can be bypassed, that corridor zoning can be changed based on individual requests, and that dense residential use belongs anywhere a developer proposes it. So once created, this precedent will be cited again and again for future applicants, and it cannot be undone. The sixth is no demonstrated community benefit. So although the applicant frames this as needed housing, there's no binding commitment to affordability, no demonstrated demand for housing at the specific site, no walkability or transit access making it a non-sustainable residential location, and no proof that community benefit outweighs long-term burden. This is not an anti-housing, it's just a pro-planning. And finally, improper bifurcation. So the multifamily housing and the institutional expansion are interconnected, sharing access, traffic impacts, grading, and infrastructure. Courts have held that when impacts are so intertwined, bifurcation is inappropriate. This application should be reviewed as a whole and rejected as a whole. So in closing, the decision is about more than one project. It is about the future of one of Bridgewater's most significant corridors, the safety of its roads, the resilience of its environment, and the integrity of its planning process. The master plan is clear, the infrastructure is limited, the environmental damage is irreversible, the benefits are uncertain. So for these reasons, I respectfully urge the board to deny the rezoning request. And thank you very much for your time and considering the concerns of nearby residents.
Thank you very much.
We also have a petition with over 600 signatures.
Can't really accept the petition, sorry.
It is validated with email address.
We can't accept the petition.
Okay.
Okay, sorry, thank you.
All right, thank you.
Any other members of the public want to speak for or against this case?
Rob Esposito, 738 West Foothill Road. Good evening. Thank you for the opportunity to speak. I'm going to skim over some of the things I prepared because it's either been mentioned by myself or others. But starting with traffic, back on August 12th, 2025, I had asked some questions about the impact of adding a driveway to an already difficult corridor, only to learn that my neighbors had already asked the same questions a year earlier, November 12th, 2024. Despite all that time, nothing really changed, so I'm going to bring up some of it again. One of the things that Mr. Keller mentioned back in 2024, and again tonight, I heard the word incidental. So 2024, he said, that's a very good word to use, incidental, when describing the impact that this project would have on West Foothill in particular. And I respectfully disagree with that, and I'll reiterate the example that I gave in that previous meeting. A driver turning right from West Foothill has to navigate, turning right to go southbound onto 202, 206, has to navigate cars coming over the hill, often well above the 50 mile per hour speed limit, and then immediately check for vehicles turning left from Foothill Road. And with this project, they would also have to account for cars entering and exiting the new driveway. All of this happens while trying to accelerate safely up to a 50 mile per hour highway. Nothing about this sequence sounds incidental. I think it very much is related to the overall safety of the highway. I had some mention of level of service here. I'm going to skip over that because of the comment that professional opinions rank higher than the layman's. But I will say that the level of service may look acceptable on paper, but anyone who actually drives the area would not describe it as not frustrating. I personally found myself making choices behind the wheel I normally would not take simply to get through the intersection without waiting 5 minutes. When turning left from 202 onto West Foothill, cars constantly beep their horns as if I'm making an illegal turn, and then aggressively and illegally pass on the right where there's no shoulder, just to avoid waiting. So what type of report is going to show these real-world scenarios? Because this sounds more like an F than a C-level service to me. Addressing stormwater and slopes, basically the point that I want to make is that the board has said in August that if this doesn't go well on a rainy day, this could be a bad situation for 6 downstream properties. And another comment was that this is not a risk the board and township can take. So I just wanted to highlight that. And then the township has already seen what happens when large numbers of mature trees are removed without a fully understood stormwater plan. And what residents are calling tree gates, Somerset County cut down hundreds of trees in Washington Valley Park. The result was, in Mayor Mensch's words, serious environmental damage and significantly increased adverse flooding dangers for downstream homes and businesses. The mayor felt strongly enough about the resulting risk that he publicly encouraged residents to attend a county commissioners meeting to demand answers. That situation involved a few hundred trees on gently rolling parkland. This application removes 407 trees on a steeper slope directly above existing homes, with stormwater report that is preliminary and incomplete. If the township is willing to take legal action, presumably with taxpayer dollars, over tree loss and flood risk outside Bridgewater's borders, it should be even more cautious about approving a private development that poses the same risks, only closer to residents and on far more vulnerable terrain. While the township would still have an opportunity to raise concerns if this project moves forward, the applicant is putting the cart before the horse. By seeking zoning approval first, they create the ability to turn around and pressure the township later by saying, we already have zoning approval for this project. Regarding the unit change count, I had questioned previously how it went from 64 to 60 to 52, and the answer was quite vague. In May 26, Mr. Chairman pressed for an explanation. The applicant admitted that they reacted to the proceedings, but then tried to avoid stating what those reactions actually were. The truth, in my opinion, is that the board believed 64 units was too dense. But when the applicant later added affordable units, not because the land changed, but because the variance argument needed help, the count went right back to 64 units. Nothing about the traffic changed, nothing about stormwater changed. The only thing that changed was the applicant's strategy. This is not planning. And importantly, there's no demonstrated need for the project. A board member plainly stated, "I don't know anyone who wants this." Another board member pointed out that other age-restricted units in town remain vacant or unsold. When asked, the application's planner admitted that he did not perform a market study. He does not know whether the existing senior units are occupied, and he cannot say whether there is unmet demand in Bridgewater. So the applicant's own professionals cannot testify that anyone in Bridgewater needs or wants this housing. The board members have stated the opposite. Put simply, there's been things sugarcoating this, whether it be the affordable housing, the land to the JCC, which I love the JCC, and I don't like that this is involved with it. Sorry, I'll continue. Regarding the age restriction, at a previous meeting, I asked if the age-restricted communities ever get converted to market-rate family housing, and the board said they're not aware of any cases, and that the applicant would need to come back before the board to make any changes. After doing some research, it appears that age restriction is governed by federal HOPA rules, not zoning. So under HOPA, only 80% of units must be 55 plus to qualify, and those occupancy rules can be changed by the future HOA or owner without needing a variance. We've also seen New Jersey's age-restricted conversion law, where whole 55-plus developments were legally converted into family housing without any zoning change. So while the board may not personally know of a case in Bridgewater, the legal framework in New Jersey allows for these conversions. That means all of the traffic, density, and school impact assumptions built into this application depend on restrictions that are not guaranteed and not permanently enforceable by the township. So at the May meeting, Mr. Chairman, you said that if the public wants to speak, I'm going to give them as much time as they need, and I appreciate that. But I'm concerned that the public comment comes at the very end, and the board is likely prepared to vote tonight. I respectfully ask that the board take time to reflect on the feedback given and give the real-world experience shared by the residents the same weight as technical testimony before making a decision that will affect the area for decades. Thank you.
Thank you. Anyone else? All right. Oh.
Dawn Marinelli, 809 Route 202-206 in Bridgewater.
Would you raise your right hand, please? Do you solemnly swear that the testimony you will give to this board will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
So basically, I concur with everything that Lisa Ferrara said. She stated it perfectly. I oppose this project. I don't understand why the property can't be developed under the zoning, the existing zoning restriction, you know, I don't know how to say it, but I don't know why there are variances that have to be approved. I honestly feel that I am going to be negatively impacted as a homeowner. I'm worried about the flooding. I think it's going to be unsightly, and I really hope that it doesn't go through.
Thank you. All right, anyone else? Last call. All right, I'm going to close the public comment section. And Mr. Cohen, you wanted to wrap up?
Thank you, Mr. Chair and members of the board. The matter before this board includes an application for a D1 use variance for the Shimon and Sarah Birnbaum Jewish Community Center of Somerset, Hunter, and Warren counties, known as the JCC. The JCC is classified as a house of worship. The testimony by Laura Friedman, CEO of the JCC, and statements by the township planner, Catherine Sarmad, on August 13, 2024, confirm this in the transcript at pages 32 and 33. The zoning board chair, Mr. Foos, reaffirmed this status also on August 13, 2024 transcript at 33 through 36. A house of worship in this town is treated as a conditional permitted use so long as it is located on a state, county, or specifically designated municipal road, Township Code Section 126-353. In the case of the JCC, albeit in existence for 25 years and prior thereto, it does not have frontage on state, county, or specifically designated roads, hence the need for a use variance in this particular case. The specific relief here as to the JCC is focused upon the rear 3 acres of Block 477, lots 45 and 46, which is contiguous to the existing JCC campus. This board has heard testimony from Ms. Friedman, the CEO, and the executive director of the JCC, transcript August 13, 2024, at pages 23 through 43. That testimony included the JCC's intended use of the 3-acre parcel for religious, educational, fitness, social, day camp, and community-wide activities in furtherance of its Jewish mission, and notably and importantly, consistent with all activities presently occurring on the JCC campus. Thus, in this particular scenario, as to this specific use variance, the JCC is not seeking a change in use. The only reason it is before this board is because the ordinance requirement relating to state, county, and municipal roads requires a use variance for the reasons I stated earlier. The board has also heard statements from the township planner and the zoning board chair recognizing that ancillary uses, such as those engaged in by the JCC, fall under the House of Worship umbrella, August 13, 2024 transcript at pages 30 through 36. It is also worthy to note that the JCC has enjoyed an excellent relationship with the community and with the township. While it has a Jewish mission, its campus activities are open to all faiths and persons. The JCC has also partnered with the township in annual community days. Further, worthy of note is that neighboring property owners to the JCC speak highly of its reputation and relationship with the neighbors, evidenced by, among others, testimony by Laura Rickey, living at 771 Talamini Road, August 13, 2024 transcript at page 27, and indeed Mr. Esposito tonight. Thus, the sole reason before the zoning board as to the JCC use variance application is whether it meets the standards set forth in the municipal land use law governing a use variance. Let me speak briefly to that law. As to the requirement that there be both satisfaction of positive and negative criteria to justify the granting of a use variance, first focusing on the positive criteria. The positive criteria involve particular cases and special reasons. This is spelled out in the recognized legal treatise, GAN, New Jersey Zoning and Land Use Administration, which states very specifically, regarding positive criteria, the court has stated that special reasons take its definition and meaning from the general purposes of the zoning laws enumerated in NJSA 40:55D-2, citing Burbridge versus Township of Mine Hill 117 NJ 376, and in Saddlebrook Realty versus Township of Saddlebrook Zoning Board of Adjustment 388 NJ Super 67 at page 76, where the court observed 3 scenarios in which special reasons may be found to justify the granting of a use variance as to satisfaction of positive criteria. 1, the proposed use inherently serves the public good. 2, the property owner would suffer undue hardship if compelled to use the property in conformity with the permitted use in the zone. And 3, the use would serve the general welfare because the proposed site is particularly suitable for the proposed use. In this particular matter, the special reasons just described to you are met in at least 2 of those scenarios. First, the proposed use of the JCC, i.e. the rear 3 acres, inherently serves the public good. The JCC is a religious organization serving the needs of all who wish to join. The fact that the organization is of a religious nature makes it inherently beneficial. That has been stated repeatedly during the course of these proceedings and indeed this evening. Second, the use would serve the general welfare because the proposed site is particularly suitable for the proposed use. The layout of the JCC campus makes its parcel particularly suitable for the proposed use as it permits growth of outdoor experiences in the area where it will be most useful to the mission of the JCC, to which Ms. Friedman testified, and indeed, during the course of these proceedings, the inherently beneficial use has been repeatedly acknowledged. As to the satisfaction of the negative criteria, the second arm, so to speak, with respect to justifying the granting of a use variance, NJSA 40:55D-70D(1) states that negative criteria are satisfied so long as the relief can be granted without substantial detriment to the public good and without adverse impact with respect to the zone plan and the zoning ordinance. In the case of the JCC, an inherently beneficial use as to satisfaction of negative criteria has been discussed in the well-known case of Sika versus Board of Adjustment of the Township of Wall, 127 NJ 152 at pages 162 through 166, a 1992 Supreme Court decision. In that case, Sika identifies a four-step process that the zoning board shall use in determining whether an inherently beneficial use meets the statutory criteria of negative, meets the negative statutory criteria. That four-part test is: 1, identify the public interest at stake; 2, identify detrimental impacts, if any, which would result from the granting of the use variance; 3, determine whether there are any conditions that are warranted in the granting of the use variance; and 4, a weighing test, a balancing test of the positive versus negative criteria to determine whether, on balance, the grant of the variance should be satisfied. Here, the testimony of Ms. Friedman, Mr. Steck, the professional planner, and acknowledgments by the township professional planner, the zoning board chair, and neighboring property owners collectively demonstrate that the JCC meets the statutory negative criteria test. The 3-acre parcel sought to be added to the JCC property is contiguous to the existing campus. There is no change in use. The JCC enjoys an excellent relationship with the town and with the neighbors. It provides services regardless of religious persuasion, and it will not have any impact whatsoever on any of the properties in question, given the nature and location of the 3-acre parcel in relation to the JCC campus. For all these reasons, the JCC respectfully requests that the board, in its discretion, grant a use variance to the JCC. I additionally request that the board, after the conclusion of its deliberations when voting, please vote upon the JCC use variance as a separate matter before voting upon the 821 application. Lastly, I have one additional observation, and is simply based upon my experience. I have been practicing law for in excess of 50 years. I've spent a significant part of my career handling complex land use matters and trials resulting in precedent-setting decisions. I am keenly aware of the significance of master plan and zoning issues, having served as special counsel to numerous municipalities and special master to the court. I recognize that boards like this necessarily have to balance master planning and zoning considerations when confronted with use variance applications to ensure maintenance of integrity of municipal planning and zoning. I trust that in this particular instance, the board will find that balance has been struck in relation to the JCC application, and I respectfully request that the variance be granted. Thank you very much for your consideration.
Thank you, Mr. Cohen. All right, the application portion, oh, Mr. Coakley, I'm sorry. Are you going to wrap up? I thought you were done. I thought I got off easy. The microphone is yours.
Thank you. So I endorse fully what Mr. Cohen just said very well. And not often does a board get an opportunity in a single application to benefit 3 different properties in the context of a single application. But looking deeply, that's the case here. First, the obvious part that the JCC is allowed to modestly expand, which is an absolute sine qua non of this application, that the JCC gets 3 acres of property. Secondly, that the need for age-restricted housing is fulfilled. And I say that because there's a whole raft of state, federal litigation findings that age-restricted housing is necessary for the people of New Jersey. It's been found by the legislature in the Fair Housing Act that was just adopted in last year. Your census data reflects a growing cohort of age-restricted, of people who need age-restricted housing. So that comes out of this application. And the third thing that comes out of it, and maybe it's a little bit hard to discern, but this property is a target property. What do I mean by that? What I mean is that the Mount Laurel Doctrine is embedded in our law. It's not going to go away. This property is an ideal property for housing, so that you might decide not to approve this property for a modest project like this at this time, but it will still be there. And there will come a day when another board will be sitting here and will likely be facing a far greater project than this one. This is a density of 5 units per acre. That's the minimum that the affordable housing advocacy groups will even consider, five an acre. But most affordable housing projects are 10 units or more per acre. In fact, if you look at the developers who came along and spoke to the planning board with respect to their fair share plan, they had huge numbers of density per acre. 10 may have been the minimum, but they had 10, 20, they even had 40 in some parts of submittals by applicants to get more density. So Mount Laurel's not going away. A few years from now, somebody will come by and say, gee, this is one of the last remaining properties, and we want to develop it, and we want to solve all of Bridgewater's affordable housing needs. And those needs are not going away because of the nature of Bridgewater, its prominence, its success as a municipality, its populace. All of the things that make Bridgewater such a great town are still going to be there. And people are going to look to build a humongous project on this property if it's still available. Whereas the opportunity today is to accept the most modest affordable housing project you could conceive of. And that's a real choice. So it's, do you make a choice where you preserve what's there now, preserve the trees or the vegetation, when you know they're going to be gone in the future? That property is not going to be what it is now. It's time to accept a choice for that property that will benefit the neighborhood in total. Because there's lots of reasons why this variance should be granted, but the first one is take a modest property, a project like this, and run with it. rather than turning it down and leaving it to another day. You know, there's lots of properties over time that get varianced and varianced. There's application after application. I've done several of them myself. But, you know, normally the board has to think big picture. And big picture is come up with an approval in a situation like this where you have a modest application. You know, you have 3 acres going to the JCC. How often does that happen? You have 12 acres. It's only a density of slightly over 5 units per acre. You have quite a bit of space around the project. You know, you have a lot of good things with this application. My suggestion is don't let it go by because it won't come by again. So the easiest thing to do is to kind of think the existing condition can be preserved when you know in your heart it can't be preserved. It won't be preserved. Time marches on, and laws continue on. And Mount Laurel Housing is generating a whole lot of development in New Jersey, and it will continue to do so because that's always going to be part of the law. It will never be gone. Anybody who thinks otherwise is kidding themselves. So, you know, the JCC use variance was explained very well by Mr. Cohen. I won't try to elaborate on that. But there's three grounds, primary grounds for a residential use variance. First is the most obvious, which is that it is a particularly well-suited use for this property. And why do we say that? Look what's in this zone, this 202 zone, this corridor. First is 287, there's 202. It's a state highway. It's surrounded by non-R40 development. In fact, when was the last R40 development in this that was actually built in this area? Look at all the uses. There's commercial, there's retail, there's large houses of worship. There's all sorts of uses, but I don't think there's been any R40 for many years. So this is a proposed use that is modest compared with what's there already. So I think that you can well see that this site is particularly well suited for this use, which is much less than what's been approved there for umpty-ump years. Secondly, it's affordable housing. Now, all of the courts of New Jersey have you know, taken on affordable housing. They've made it their poster child. New Jersey's a leader in the country for mandated affordable housing. But that has led to judicial decisions. You know, and in particular now there was, the one I'm thinking the most of is one where a Board of Adjustment turned down a use variance like this for a low-income senior project. Sounds familiar? And in so doing, you know, the court said, we are convinced that the council's denial, and that was actually decided by a city council where you could appeal to the council from the Board of Adjustment, not the case in Bridgewater. We are convinced that the council's denial of a use variance was arbitrary and capricious. In reaching that conclusion, we are mindful of our obligation to accord the action of the governing body, not adjustment, the presumption of validity, and to defer to its judgment and its knowledge of local conditions. Initially, we are convinced that a nonprofit housing project for low-income senior citizens inherently serves the general welfare. You know, we all know that in our heart. We don't have to have judges tell us that. But projects for seniors, it's a good thing. You know, we all would like to probably live in one someday, or have our parents or siblings live in one. We know that can't be contradicted because it's the truth in our hearts. So that's, I guess, the number one ground. you know, it's a project that is age restricted. It's 55 and over. It's no school children. It's good financially for the municipality, and it's one that there's a ready market for. Based on all of the census data that's been provided. In fact, the legislature in 2024 adopted a law which encouraged age-restricted housing by saying 30% of a municipality's affordable housing obligation could be age-restricted. That's a big encouragement to people, to towns and developers who want to do affordable housing, to give them 30% of it can be age-restricted. But courts have said over the years, you know, that there needs to be recognized, you know, as the situation such as this. You know, so, you know, there's a case called Homes of Hope, which said that, you know, you can't use a flat 20% as the reason for a variance, but you can do, and you should do, site-specific analysis of an application. And if the application is a good one and presents affordable housing, that use of the property is sufficient to allow for a use variance. So I know the law may be somewhat in flux on that, but there is that Homes of Hope case that's very, very much on point with doing a site-specific analysis. And I think, again, if you do that here, you come to a conclusion, this is a darn good site for affordable age-restricted housing. So what are the other factors should come into mind here, besides your gut reaction to what's right? Well, it's particularly well-suited, and there are a number of factors here. It's isolated. These streets of this R40 area, none of them connect into this property. It was developed over years with streets that simply don't connect. So, you know, you can't readily create a neighborhood or a street here because it just wasn't laid out that way to begin with for some reason, or people were haphazard or not thinking of it, but that's one of the factors. So that this development, as proposed here, you know, goes out to the State Highway 202. It's essentially a standalone neighborhood, and will have a lot of benefits to the neighboring properties, including stormwater and wetlands management and things like that. But it's, unfortunately, it can't be connected. But that's a reason why you should grant this variance, because it's isolated. You know, the Route 202 orientation, this is on a major state highway. I know the town has an interest in this. I'm not saying they don't. But that interest is less than the normal case if they were building this on a local neighborhood that didn't have a state highway running by it. So, and the orientation, I mentioned this before, of what's out there on the state highway and what's been approved in this corridor, it's a dramatic departure from the R40 zone. It's been honored in the breach. The JCC connection is an important element of this. The people who live here will be benefited by and will benefit the JCC facilities, and that's an important consideration. I mentioned the modesty of the proposal. It's such a low density, it's almost unheard of in affordable housing law. But you know, that's because of the nature of Bridgewater and how it's such a good place to build the project, even though it's going to has very tight constraints and very limited in the sense of being able to absorb this. But it's not 10 acres, it's not 20 acres, it's just 5+ acres, units per acre. There's almost no disturbance that wouldn't be present if you developed this property for R40 uses. You know, Mr. Michello testified that it's it's essentially the same because you'd have to run the roads out to 202 in either event. It's just a different configuration, but you spread out our 40 homes throughout this 12 acres, and you put in the roads necessary, it's gone. It's gone. Whatever you're seeking to preserve is gone. It's not going to be there anymore. So I think the best thing to do is to recognize that and try to come up with, accept the idea that this low-density project is a darn good idea. There's certainly no financial disability to the municipality from this proposed project. There's a lot of benefits to the municipality, let's face it. As far as the negative criteria, you've done 10 times more in terms of your investigation of this property than anyone would do on a simple use variance. Use variance, you wouldn't have all the testimony that's come into this case over the last 10 or 11 months. You also have here, this is a major DOT project. They would have to get a major access permit, and they need DEP permits for stormwater, flood hazard, wetlands protection, you name it. It's the gamut of DEP programs is at work here. To conclude, this case tests your judgment. When I say that, you join the board to make important public policy decisions. This is an important public policy decision. Do you try to advance the general welfare as the state has explicated it by having a project that is modest and confined, or do you take your chances and turn it down and see what happens in the future? And the only thing you could say for sure is going to happen for the future, this project will happen again, but the only thing will be a lot bigger and will be less good for the neighborhood than this project. So we ask you to consider this using your good judgment, but using that judgment in a broad way, not a narrow way. All right, so thank you very much.
Thank you, Mr. Coakley. All right, Mr. Cohen, upon your request, I'd like to break this up for the board. We've had, since August of last year, we started this case. It's been a long time. We've had different moving targets, and frankly, it's been a little bit confusing. I think you both did a great job summarizing for us. As per your request, I'd like to break out the JCC component, and what that means is the application component of this case is done. We're now going to open it up to the board deliberations on the JCC use, D1 use variance that you requested. We both agree it's inherently beneficial use. You've granted the 4 ways that this board can go about reconciling that fact. Board members, and I'm just going to start it from my left, take it down to my right. The vice chair and the chairman are going to deliberate last. Board members, you have board professionals at your disposal. And let's open it up. Let's go to Mr. Vesio. We're going to talk about the D1 variance on the JCC case that's been requested.
Yes.
And please, start us off.
The 3 acres being provided to the JCC for this to be used as part of their facility and for religious purposes, I do agree it is a beneficial use. And we'll vote yes for this particular variance on this application.
Thank you. Mr. Fresco.
Yeah, I support it.
All right. Mr. Sweeney.
I absolutely support the application with respect to the JCC. It's a wonderful, world-class organization, and anything we can do to help them, we should do.
Thank you. Mrs. Amin, your thoughts on the JCC D1?
D1 use variance, yes, I'm in favor.
For the JCC? Okay. Mr. Bongiorno.
I support this piece of the application.
All right. Mr. Gajewski.
I'm in favor of the expansion for the JCC.
Mr. Kulak.
Yes, I would agree as well, and I support it wholeheartedly.
All right, Mr. Gabbett.
I think that the JCC is an asset to the community. I love the idea of extending the open space, so for that component, yes, I would be supportive.
Mr. Wiley.
I'm in support of the JCC.
I am as well. It sounds like the board has unanimous consent. Open up the floor to any motions on this component of the case, the JCC D1 variance.
I'll make a motion.
All right, that's Mr. Fresco. Do I have a second? Mr. Bongiorno is the second. Nancy, could we call, this is to vote on the D1 JCC use variance.
Mr. Gajewski,
Yes.
Mr. Bongiorno,
Yes.
Mr. Fresco,
Yes.
Mr. Sweeney,
On the JCC use variance, yes.
Mrs. Amin,
Yes.
Mr. Wadley,
Yes.
Chairman Foose.
Yes. All right, that takes care of that component. Thank you, Mr. Cohen, for your service and for your help in this case.
Chair and members of the board.
You got it. All right, Rich, could you take us through what's left in this case, the 821? We have a D1, a D5 density variance, and a D4
Yes.
FAR.
So, and as I outlined in my memo to the board, there's only the 3 variances that are at issue with respect to this case. For the multifamily lot, it's just the D1 use to permit the attached multifamily dwellings where that use is not permitted. The D5 density variance to permit 64 dwelling units, 51 would be market rate, 13 affordable units. And the D4 FAR variance to permit a floor area ratio of 42%, where maximum of 15% is permitted. Should there be a motion to approve, there, we discussed some conditions with respect to this application. I have 6. So there would be, all units would be age restricted at 55 and older, with no person allowed to live there younger than 18 years old, and there would be no 20% limitation. Provide a reciprocal emergency access easement through the JCC lot that would serve both lots 45 and 46, and to which would be made available for use to the neighbors. The applicant would also recommend to the NJDOT a striped left turn lane at the entrance on 202-206 North. And they would provide a 20% affordable housing set-aside, and the affordable units shall be integrated with the market units. So in other words, no separate affordable housing building. They would provide the fire hydrants as requested by the fire department when preparing the site plan. They would comply with Bill Burr's report when preparing the site plan. And as we discussed this evening, there'd be no left turn out of the project onto Route 202-206, provided that restriction is approved by NJDOT. And the exit would be designed to prohibit left turn lanes with the curbing that was discussed.
All right. And Rich, if favorable action is voted on by this board, what would the next steps be for this applicant in terms of site plan?
And with the JCC, this is applicable as well, right? So this is only the use aspect that's before the board. If this application is also approved, the applicants, in plural, would come back to the board for 2 things, right? One would be to subdivide the approximately 3 acres that would be transferred over to the JCC lot, and also for site plan approval for the 821 lot. I don't think there's a site plan needed on the JCC lot because we're not adding anything there.
I think there's a need, Mr. Aller, but certainly will respect whatever the township professionals direct.
Yeah, okay. We did talk about the possibility of a variance for the JCC lot as part of that subdivision, only because you have that barn in the front or something, but,
The lot line was adjusted so that we're clear of the setback.
yeah. So, you know, it's probably just the subdivision that then gets transferred over to the JCC and the preliminary and final site plan for 821.
Now, for members of the public, Mr. Aller, in the next phase, if this was to be approved, would the members of the public have participation in the next phase of the hearing?
It's the same, yes, it's the same procedure. So it'd be on notice. Both of those applications would be on notice to the public. Hearings would be held here, and you can ask questions of witnesses and comment.
And in your opinion, would the negative criteria brought forth in this case be relevant and be able to be effectively reopened in the next phase?
Well, it doesn't get reopened for the use aspect, but it is applicable to the variances that are required. So there was some discussion about, later bulk variances with respect to the 821 lot. So the positive and negative criteria for bulk variances would be applicable to that.
Okay.
Yes.
There's nothing further. Rich, let's open it up. Mr. Vesio.
Okay, so this application has really this variance has two sort of components. One is the use variance allowing multifamily housing, and the second, as I understand, is the density that's being requested. And Mr. Oler, please jump in if there's any part of my testimony, the deliberations that is incorrect. On the use variance, Mr. Coakley, I do believe is correct to say that this lot has been vacant. There hasn't been R40 development on this lot. So is multifamily housing appropriate on this lot? Considering the location, I could say that, yes, that's something I could support granting, is allowing for multifamily housing. On the question of density, this is where I do not agree with Mr. Coakley. As seeing the last exhibit provided by their civil engineer showing an affordable housing unit, I understand that those units would be integrated with the greater units. But what is not clear from that site plan is how you would fit 64 units when the prior presented plan before this revision showed 52 units, and somehow we get 64. So what I am against is approving 64 units for this site for your density variance.
Mr. Vesio, I do want to point out, though, it would be incumbent upon the applicant at the time of site plan, right, to fit 64 units integrated into however many number of buildings, integrated with the market rate units, right? They're not obligated to come back with 64.
Right.
They could go up to 64.
I understand.
So if there were environmental conditions, for example, that prohibited them from being able to fit 64, then conceivably they would come back with less. Okay?
I understand. The exhibit provided here is signed and sealed by a professional engineer in the state of New Jersey. I understand this to be a professional document, and they stand behind this. So if this site plan is not possible, what is the purpose of providing the board this site plan that has a...
But it's an example of what could be proposed in a site plan. And during the testimony, I'll just remind you that, it was agreed that there would not be one single building. Like right now, that example showed the affordable units in one building, right?
Correct.
And, there was lots of discussion about not doing it that way and integrating the affordable units into the various buildings with the market rate units, right? So the ultimate plan would be similar to what they're showing you, but different. Okay. So they're not married to that particular plan, is the point. That's an example of what they could do, but will not do because of the conditions imposed now integrating the affordable units and market units. Okay? So I just don't want you to think that had to be the plan. It doesn't. Okay?
No, I understand that. I understand, when I see a presentation here, seeing 64 units or versus 52 units, and we're approving the density here. So what information can I use to judge? So if I say that, fine, I'm comfortable with the use being multifamily, but no, I'm not comfortable with this density. What is valid to say that 52 units okay, 64 units no? How do I make that determination that would hold up in a court of law?
So, we're working off of what has been presented by the applicant as an example. It's the testimony was that 64 units has a density of 5, just over 5, I think under 6 per acre. Obviously 52 would be a even smaller density. The standard for the board is just not to be arbitrary in your decision-making, right? So, if you can look at their example and say, you'd have to say, I understand this isn't exactly what you're going to come back with because, we would impose a condition integrating the units. But you'll see something similar, road configuration, maybe a few less buildings, maybe different size buildings to get you to the 64. The issue is, 64 is the requested density. Up to 64 is the requested density on the property. Okay, and does that work for you?
All right. So I will leave my deliberations at, in general, the use of multifamily, I would support.
Fresco.
Okay. It's funny, Mr. Coakley, you said tonight, that it was a modest application. And I remember that day, the first meeting where you said it was a quandary. I disagree that it's a modest application. And although you're a pro, and I think you did an excellent job, this was a great presentation, and it's a massive project that, I bought into what you were saying. Maybe you're right. Maybe if it gets turned down, maybe in 2 years, somebody comes in with 122. So I commend your points, but I have to disagree. I really do. It's too big. The FAR is too high, the tree count is too high, the flood risk damage is too high. I mean, this is fact. This area has been hit with water issues, right? I mean, we hear about it, we see it. It's a major DOT project, it's a DEP project. And I think, frankly, it's irresponsible to cut into 2026 at this location. I think your traffic expert, for lack of a legal term, was wishy-washy. He's got data telling us that, that there's a lot of volume and it's not going to affect us. I buy into that. I think these folks can take 13% more. But what I don't think we can handle is that intersection. We had testimony, or I guess commentary, from a business owner across the street who came in, and I wrote it really fancy, but I'm just going to speak to you. He came in and said, hey, I benefited from a driveway access, and I appreciated getting it granted, but I don't even support this. Right? Mr. Chairman Foos's vet clinic, I forget the owner's name, came in and actually said it. He said, I got it, but I wouldn't want it here. It's too dangerous. And that was my point to your traffic expert. It's not about the volume for me. For me, it's about navigating all of these intersections and just cutting into 2026 anywhere you want. Frankly, to the residents, I am here right now because I was there. And for those of you that know my history, that's why I'm here, okay? Because it was in my backyard, and I did fight for it, okay? And the truth is, these guys are gonna probably try to bring this to a court and a judge. And I wanna see a judge tell us that we have to accept 576 trees being gouged out of Bridgewater in an R40 zone. I'm gonna leave it on this. This project is perfect for its use. If the guy selling the property to these gentlemen lowered his price, maybe they could still make money on putting in 12 houses. Maybe we don't have to cram 62 in. Maybe we can get away with 12 and we can put a road. So frankly, it's too big. I cannot support it. I'm sorry. I want to, and I appreciate that you made concessions. I really do. I wanted to go with the right only, but I just can't do it. I'm sorry.
Thank you, Mr. Fresco. Mr. Sweeney.
Thank you, Mr. Chairman. I want to say right up front that this is one of the most egregious, flagrant examples of overdevelopment that I've seen in nearly 20 years on this board. But since overdevelopment can mean different things to different people, let's take a look at some of the specific measures we traditionally use to get a handle on and to identify overdevelopment. One of those is density. Our land use ordinance stipulates the maximum number of residential units that can be built on any property, depending on the size of that property. In this case, the maximum number of units permitted on this property after 3 acres go to the JCC is 12. 12. The applicant wants to build 64 units. That's 5 times the number that's allowed. Floor area, another measure we look at. Our land use ordinance spells out the maximum floor area that can be developed on any property. In this particular zone, the maximum floor area allowed is 15% of the size of the lot. The applicant wants to build out floor area that's 42% of the lot size. That's almost 3 times greater than what's permitted. Lot coverage. If this application is approved, then the developer will at a later date request a lot coverage variance. The land use ordinance also spells out the maximum amount of lot coverage that can be built out on any property. And in this zone, the maximum allowed is 18% of the overall size of the lot. But the applicant wants to cover almost half of the entire lot with paving and other impervious coverage. That's almost 3 times what's permitted. Now, these are specific metrics that let us look at overdevelopment and intensity. And in this particular case, they tell us that it's too big, it's too massive, and it's just too much. And it screams overdevelopment and overintensity. Particular suitability, let me touch on this for just a moment. The applicant needs a D1 use variance if this project is to move forward because the attached residential dwellings that are proposed are not permitted in this zone. One of the proofs that are required if the applicant is to get the D1 use variance is called particular suitability. In other words, the applicant must show that the proposed use is particularly well-suited for the site. I'm not going to go into a lot of detail here because the Bridgewater Police Department did that for us. And they found that the project's impact on traffic volume, congestion, emergency response times, and everyday commute represent a potentially significant negative impact on the public good. The last thing I want to mention very briefly is buffers. Any applicant trying to get approval for a project of this size will typically talk about buffers, the trees, the bushes, etc., that will tend to reduce the visual impact of what they want to build. Well, here's the bottom line on buffers on this lot. The applicant's proposing to go in and clear cut this lot, taking down over 400 trees and then paving over much of the property that's not built. In summary, if this project is allowed to build out, it constitutes a serious overdevelopment that threatens a substantial detriment to the public good, and it should not be allowed to move forward. I will vote no on this application.
Thank you, Mr. Sweeney. Mrs. Amin, your thoughts, please.
Looking at the density and also the floor area requirement, I would go with Mr. Oller's suggestion that X number of maximum units. And I would say if I go with a yes vote, I would suggest that the number of units at the time of site plan approval should be reduced down to maybe like 30 units or 40 units, between 30 and 40 maximum, if I vote yes. And then with that the floor area ratio will also go down.
Thank you.
Before we do that, I just want to say to Ms. Amin, but that's not the application, right? So they're asking for 64.
No, but I would say.
Right.
No
So as
more than
Mr.,
40.
so I think it was Mr. Fresco who basically said, or maybe Vesio said, the use is okay, but the density's the issue. That's what you're saying?
Right.
Okay, thank you.
Thank you, Rich. Mr. Bongiorno.
D1, D4, and D5 variances are pretty much the largest over what we allowed that I've seen on my 5 years on the board. But as stated by Chairman Foose, this board focuses on safety, stormwater management, and inherent use of servicing the public good. We try to find acceptable yes to applicants because in commercial developments like this, if we say no, we're going to get sued. I listened and I heard the comments of the residents. And I regret the potential loss of the tree environment. I'd like to believe that the conditions we will impose will satisfy safety and storm management. And one other thing I'd like to add to the conditions, Rich, is that they have stated there will only be one HOA, not two. As for the public good, affordable housing mandates come from the state. We don't have much of a case to stop them. But Bridgewater must provide a substantial number of affordable housing units. As a takeaway, the other restricted age development in Bridgewater that we approved 2 years ago seems to be on hold for various reasons. One being that nobody wanted to buy them. So I'm not sure how I'm going to vote on this. I still have a lot of questions and a lot of concerns, like the rest of the board members do. That's where I am right now.
All right, thank you. Mr. Gajewski.
Yeah, I think the members of the board have really nailed all of my concerns. The challenge that the density is a huge concern here. I think some of the things that are playing into this too are there is an age-restricted housing that's needed. There's this desire for premium high-end really complicates it, and I don't think that by adding that in, it plays to all of the things that the state necessarily is looking for. But that aside, I think that it is definitely, the density is much higher than I think I'm comfortable with and what this particular lot in this area can handle. And at the moment, like I said, I'm not in favor of this application right now. I will say, though, to Mr. Coakley's point, and the JCCs, it is good to be able to have some say in what can be done there and what will be done there ultimately. How we get there, I don't think it's by arbitrarily picking 64 units and then saying we're going to figure out a way to fit them in here afterwards. And I think that was the mistake in this one in my mind. But right now, I can't say I'm in favor of this.
Thank you. Mr. Kulak.
A lot of the board members have made some really compelling points with respect to density, with respect to the impact on the environment, with respect to the concerns as expressed by the homeowners. All those things are true. Where I differ is that the state has a very powerful tool under the fair share housing laws that it can use to impose development on sites like this. And that's true statewide. We're surrounded by it and we're affected by it. And we have, through our council and our mayor, a plan, and through our planning board, a way in which we can meet the obligations of the state. But the state can come in and really use their power to create a development that is far greater in scope and density than that which is proposed. The one which is proposed is a tough pill to swallow. 5 units per acre, still, as Mr. Coakley points out, at the lower end of the density of affordable housing projects. Doesn't mean I'm in agreement with it, but I'm also looking to balance the scales by saying that if this were to be approved with the appropriate conditions, then the JCC benefits and the community benefits from the JCC. The other opportunity is to fix a development that is lower in density than could possibly affect you in the future. The property at some point will be developed. The question is when and how, and if it's developed in any way, whether it's for single-family homes or multifamily homes, it's going to be clear-cut, period. That's going to happen. So the question is, do you want to kick the can down the road? The board can make that decision. And I sympathize with the homeowners because I have been too in your seat and still am. And the density of the project that is near and dear to me is far in excess of that which you would be subject to. It's a tough pill to swallow, I get it. But in this case, I don't know how we can balance it, and I can see where the board's opinion is. I just wanted to give you the alternative view. Thank you.
Thank you, John. Mr. Gabbett.
So, as I believe Ms. Ferrero mentioned in her testimony, I too am concerned about the precedent it sets for future projects in sheer size, in density. Mr. Keller also discussed at length the importance of data. For my background, I have a master's in communication information studies, and if there's anything I learned from that educational experience, it's that data is a phenomenal tool, but data interpretation within the confines of a vacuum does not always properly incorporate all aspects of reality. So in summary, Mr. Coakley kept using the phrase, you know it in your heart, you know it in your gut, and in my heart and in my gut, I believe that we should do no harm, and I believe that this project as proposed risks harm in particularly to those who already live there, so I would not be in favor of this.
Jim.
Yes, actually, Ward said quite a bit here. First of all, I really want to thank the neighbors for coming out. We actually do this, and I've been on the board for close to 15 years. You're the ones that live there, and I need input from you, and I'm sure the other board members do as they have to say to you. What I've been wrestling with for over a year now on this project is, and I don't live too far from where the property is at some point the property will be developed. You know, whether it's now or 5 years or 10 or 20 years down the road. I explain that to my wife a lot of times when she asks me how to go or this is coming down or what. I say these properties will be developed. And I'm not going to rehash what Mr. Fresco and Mr. Sweeney said, because I agree with a lot of what they said, is that we started out at around 60 units max, went down, and I really wanted to go down more, and we went the other way by adding in affordable housing. So I really think that I have a problem with the density issue here, as well as possible drainage issues and everything else that my other members down there had said. So I am not in favor of the application.
All right, thank you. Boy, this is a tough one. And I think first, like Jim said, thank you, members of the public, for coming out. I know myself, I started this whole crazy involvement in politics because I was sitting in your seat. I know how it feels to get the notice that the hearings are going to happen. And to sit here for umpteen hours over the course of a year and 3 months, it's rough, and I'm incredibly sympathetic. The reality is the new normal of living in New Jersey is affordable housing. Whether you like it or not, this property is going to be developed. And if you've listened to any of the hearings in the last 1 year and 3 months, you've heard how incredibly tough I've been on Mr. Coakley. At one point I walked out of here, I thought he was going to punch me. He said, I'm the reason I drink, referring to me. It's a compliment. That means I've done my job. And, you know, I respect him tremendously, and I think in his summation, he correctly points out that if you don't approve this, beware what awaits your future. And, you know, at 5.37 units per acre and an FAR of 45%, Mr. Kulak can testify what's going in next to his house has significantly higher ramifications in terms of both properties, residents per acre, and the FAR. So with this case, we get to manage a very difficult decision. I'm in favor of it, and I'm in favor of it for this reason, is that this is the first phase. We're only approving the use variance. Whether 12 houses go in or 64 townhouses go in, those trees are gone. At least with this, there's another site plan hearing where you can go and talk about the buffering that you're needed. The vegetative buffer is so important to West Foothill. We've gotten concessions out of the applicant for our right turn only. That makes this inherently more safe. And trust me, I am there at the veterinarian hospital too often. It's a dangerous intersection in my opinion. The problem is my opinion doesn't mean much. I'm not an expert. So I think the board is stuck on a couple issues. And when this application started, I always bring up the issue of bifurcation. And bifurcation is complicated. And there's a lot of case law that talks about bifurcation may be inappropriate when a use variance and site plan issues are inexorably interrelated. In such cases, it is better to consider both applications in a single proceeding. That may be the case here. I think this board would have been better served to have everything come out at once. It would have been a longer hearing. We could have found out where the trees are going. We could have found out what the potential renderings look like. We could have had simulations. We could have had some better drone shots. That didn't happen here. They basically gave us the bare minimum, and I think the board has reflected that bare minimum. Do I think it's enough to grant the D variance component? I do. I'm going to be voting in favor of this. And unfortunately, this is the new normal of affordable housing in New Jersey. The elections do have consequences, and Trenton is emboldened to put affordable housing onto all of us in the state. So, Rich, anything further?
No, I think there's, well said by the board, and time to make a motion.
Okay. We'll open the floor to a motion, please. This is on the D821, D1, D5, and D4 FAR variants.
I'll make a motion to reject.
I second.
All right. So that was Mr. Fresco on a motion to deny, and that was Mr. Sweeney on the second.
Okay, so with respect to that motion, if you vote yes, a yes vote is to deny the application, not approve it. A yes vote is to deny the application. Okay?
Nope.
Can I abstain?
No.
No. Don't you dare. Yeah, don't you dare.
No.
You can, but.
No, you can't.
No, you can't.
There's no, you sat through the whole
All right,
thing.
Mr. Alder has spoken.
You cannot abstain. You have to vote.
All right, we're going to call a roll call vote, please, Nancy.
Mr. Gajewski.
Wait, let's just review. A yes vote means to deny the application.
Correct.
Correct?
Correct.
Okay.
Mr. Bongiorno. Mr. Fresco.
Yes.
Mr. Sweeney.
Yes.
Mrs. Amin.
No.
Mr. Wiley.
Yes.
No.
Okay, so the motion fails. So is there another motion, a motion to approve?
Shall I make a motion to approve?
Okay, I have Mr. Gajewski making a motion to approve. Would you like to second that,
I
Mrs.
will
Amid?
make a motion to approve
A second.
with the D5 density, if they can reduce the number of units during the site plan approval.
No, that, it's only for 64, up to 64 units,
Okay.
right? And there actually is a motion pending to approve
The 64
the 64, up to 64 unit density.
That it's a motion to approve on the 64
okay,
units
I'll
and the
make a
D1,
motion.
D5, and FAR.
We're, yeah, we're approving or denying his application for 64 units.
I hate the 64 number, I'll be
Yeah.
completely honest with you. I wish you could do something about
number.
That's it, that's what you're gonna get.
The number.
Yeah,
Do you think they're gonna reduce it after? You're kidding yourself.
yeah.
They could,
We have a
they could
motion.
come back and raise it and say that's a floor.
We have a motion. Do we have a second?
Why, they can raise it, can't they? Right, they can come back to the next round and say we want 84, right?
No,
Oh, it's max 64?
maximum
Is
64.
minimum 64?
No. Maximum
Max is 64. Okay,
units.
good, thank you, good,
Okay.
okay. You're right, fair enough.
We have a motion on the 64, three use, the D1.
So Mr.
the D5,
Gajewski
and
made a
D4.
motion to approve that, the 821 application for the D1, the D5, and then D4 variance.
Looking to the board for a second, please.
Is there a second?
Yeah, I'll second.
That's for 64 units. Okay, you're seconding Mr. Gajewski's motion. Nancy, give a roll call vote.
Mr. Gajewski? Yes. Giorno? Yes. Mr. Fresco?
No.
Mr. Sweeney?
No.
Mrs. Amin?
Yes.
Mr. Wadley? No. And Chairman Foust?
Yes.
Okay, so there's 4 yeses and 3 nos. So the motion to approve does not pass because you need a supermajority. So therefore, the application is denied.
All right, thank you, board. That was a tough case. It was a long case. Our next meeting, Nancy, December 9th, we have a residential case. And thank you, Mr. Coakley, Mr. Cohen. Thank you, gentlemen. Next meeting, this room, 7 PM, December 9th. Can you take us real quick through the cases?
December 9th.
Yes.
We have quite a few matters listed.
We
but we're,
We have a homeowner.
Yes.
We have a carrying of the Cafe Amelia application.
Yes.
On 202. We have the Rockland APV battery facility.
Yep.
And we have the continuation of the Bridgewater self.
Time to act for Cafe Amelia expires December 10th, so we're going to hear the residential case, and we're going to hear Cafe Amelia, and any time, we'll get to the other cases. I doubt there will be much extra time. So with that said, happy Thanksgiving, everyone. Thank you.
Wait, I'm sorry, one other thing. Do you need, Nancy, do you need the board to act on the list of dates that you provided?
I don't need them to act on, I just wanted them to discuss those
Okay.
2 dates in particular so I could get reorg materials ready. Takes a while.
Okay. So did anyone have an issue with any of the dates? Did you check for holidays and?
There were no conflicting holidays.
Okay.
May 26th is early voting,
Yep.
and October 27th would also be early voting.
Okay.
Had some logistical issues because of that, so I didn't know if we wanted to eliminate, as long as we have 1 meeting in May and 1 in October, it's up to, so just something to think about, and we can decide on the meeting on the 9th.
Okay.
We'll see everyone December 9th. We have a motion to adjourn, please. All right. Thank you, everyone. Happy Thanksgiving.
Thank you.